Good afternoon, ladies and gentlemen. Today is July 26th, and it's 1:04 p.m. And we are here for the purpose of a briefing meeting. We have a full agenda today. And I'll begin by asking Dr. Bernier if he has anything.
Madam Chair, members of the board, I do not have anything to say other than to thank you for your time and effort yesterday. Yesterday was a very full day, both in the morning with policies and then in the afternoon with our own board workshop. This is another full day. We did make the change in the agenda as you requested. We pulled the Naviance presentation. That presentation is being developed for all of you as a voiceover presentation to go to you through email, so that you can have the same presentation without having to be physically present. And then what we will do, as I promised, we will recycle on the 16th, I'm sorry, the 11th? The 11th of August. In that briefing, we will do a shorter briefing so that we can still take public comment on the Naviance application. So be looking for that link. I spoke with the members of the academic services. They believe they can have that link and information to you by Friday. So you'll have that information before you go into your weekend. Thank you, Madam Chair, for the opportunity.
Thank you. Okay, first on the agenda is a report from our Audit Committee.
Oh, okay.
I'll just digress for 1 minute and give Ms. Patrica a chance to explain her attendance here today.
Yeah, I've got a 4 o'clock hard stop to fulfill a family obligation. So if I get up and leave at 4, I'm not being rude, and I'm not being rude to the public. If you want to make comment, I have to leave. I do have an obligation. Thank you.
You're welcome. Okay. And our presenters today are Matt Blondell from RSM, Weiss Campbell, RSM, Paul Cohen, Committee Chair, and Jeff Davis, Committee Member. Would you like to?
Are they going there or are they going up there?
Are you more comfortable on the side there, or do you want to come to the podium? Both are available, yeah.
No, Mr. Cohen up there.
Yeah.
So that way you have space.
You can go right
on the other
here.
side.
On the other side.
So all of you can be there.
Yeah. Then the whole team can sit there.
Yeah.
Be together. Thank you.
Thank you.
Okay, thank you for your time.
Security, did you check the lobby to make sure everyone's cleared? Are there any people in the lobby? Security, are there any people in the lobby? No, okay, thank you. Welcome.
Again, thank you for your time. I'm hoping that the board members were provided with a memo that was put together, identifying the rationale behind the recommendation coming from the Audit Committee. So I'm not going to spend a lot of time going through the details of that document. I want to set the record straight because at the prior board meeting that I listened in on, there was some concern about the role of the Audit Committee. We are here strictly to make recommendations to the board. We do not dictate what the audit plan will be. We are making a recommendation as to audits that we believe are higher risk to the district, and we have to supply proper support and documentation of those recommendations. The school board ultimately has the ability to agree with our recommendation, disagree, modify, whatever the school board so chooses. And that's why we are here today with representatives of RSM to answer any and all questions that the board members have relating to the rationale behind the audits that we're recommending from the committee that the board consider having performed during the course of the following year.
Thank you, Mr. Cohen.
With that said, I'm going to leave it to RSM.
Good afternoon.
Good afternoon. My name is Matt Blondell. I'm an internal audit director with RSM. Thank you for having us here today. As Mr. Cohen stated, we've reviewed the risk assessment with the audit committee. I understand that they have recommended, which our risk assessment included top 10 items. As we discussed with the committee during their meeting, that it was on their recommendation to make to the board which items to pursue for the next coming audit cycle. I understand that they've recommended 4, and of course, they're within the top 10 that we had recommended, and certainly agree with their rationale and understanding of what they've presented to the board.
Great, thank you.
Okay, with that said, the 4 recommended audits that we have brought before the board are cyber threat intelligence, half-cent sales tax, surtax compliance, contract compliance, and purchasing cards. And the rationale, as I said, was contained within the memorandum that was provided to the board in July. We are here to answer any and all questions that you have relating to rationale as to why those 4 audits were deemed to be higher risk than the other 6 in the top 10 and the other several hundred of potential risks that the school district potentially could have. But again, we rely on the expertise of RSM. They've done multiple school districts, understand where the risk components lie. The audit committee felt confident and comfortable with the top 10 of RSM. We did add a couple of other areas that we feel that should be pursued down the road, but these 4 that we're recommending we find to be the 4 highest of the risk categories within the district's risk exposure.
Thank you for that, Mr. Cohen. Board members, any questions, comments? Discussion regarding the 4 priorities, 4 high-risk priorities. Ms. Vaughn?
Okay, first of all, I would like to welcome Matt back to our boardroom and RSM. In the past, I personally always found that RSM was a great firm to work with, and again, I'm really glad to see you guys back with us. Mr. Cohen, can you elaborate a little bit about the reasoning behind it? Was the half-cent sales tax? Could you repeat exactly the half-cent sales tax? What?
Absolutely. I think it would probably be best served if it came
Okay.
from RSM because
Okay, exactly
use
what
some of their verbiage.
Yeah, exactly what we're doing with that.
Sure. So the goal of that review would be to analyze the information that the district employees are providing to the independent oversight committee over the surtax to validate that the information that they're providing to that committee is complete and accurate and timely to allow the committee to make informed decisions. So it's really it's auditing the process of how that committee obtains the information that they receive from the district to make sure that it's complete and accurate information so that they can make the best informed decision.
Okay, and obviously I'm not an expert, but that doesn't sound like it's a really, really long process to analyze that. How long is this going to take? And I mean, that committee meets quarterly. And so, to see this as one of the 4, when I can see some other things that perhaps are more pressing or higher on at least my scale. Could you elaborate a little bit on your process of looking at that and how long that's going to take?
Sure. So it is a fairly quick audit process, but some of our other school districts, what we do is we actually, like you said, the committees are typically they meet quarterly, and then for some of our other audit committees, we do audits of the information they provide to the committee twice a year, and so it's more of like a recurring audit that we do at some other school districts, which is, again, at the request of those boards and audit committees, that we were looking at that information on a recurring basis. But it is a fairly, to your point, it is a quicker audit.
Okay, yeah, that's what I was interested in, on what all was actually being, or could be done, and the fact that that committee meets quarterly. Okay, so twice a year. So I'm assuming that at this point, that's not like the major, you're not doing one thing at a time. You're working on, I mean, you're not just working on this one and then the next. They're ongoing things from the other.
Well, we certainly look at the
Priorities.
process to understand the controls that the district has in place to make sure that the information that they're
Right,
providing
right.
to the committee is accurate and complete and so forth. And we would certainly do, like I said, when we do our ongoing testing, we're looking at have those controls changed, or if there are any allocations for things like staff time, labor, things like that. How is that process managed? How are the procurements managed to make sure that they're in compliance with statute, specifically for funds that are being used from the surtax? And then we do procedures on the data itself that actually makes its way to the...
Yeah, and I did not ask my question well, what I at all.
I understood you.
I didn't ask it well. So in other words, you're not just working on, we have a list of 4, one thing at a time. We have ongoing audits on other areas at the same time, right? And what I really want to know, what audit right now is taking up most of your time and is going to be the longest? I have a guess on this, but I just wanted to make sure.
Sure. So the way that, internally we've kind of thought through, I know the audit committee has presented a preference order for the audits. These, conceivably, some of them, like the half-cent surtax, could be going on at the same time as one of the other audits.
Okay.
But, with our typical audit plans, we usually plan them out to start about once a quarter, to kind of go throughout the year, to just have, to reduce audit fatigue on certain individuals, especially if 2 audits might have 2 stakeholders, where we're taking a lot of their time if we're doing 2 audits at once. But in this case, I think, what's been presented is really kind of a first pass at the half-cent surtax process. And if there were any concerns that came out of that, it could conceivably go into a recurring item, or if there are no concerns, I could see that it could just be a once and then move on.
Okay, thank you.
Ms. Morgan?
Yeah, so my question is about the cyber threat intelligence. Dr. Bernier, has this been recently audited?
Board Member Morgan, I'm sorry, I'm pausing because I'm trying to go back through my knowledge of all the audits that have been done. Specifically when it comes to Halfpenny, no.
No, I'm talking about the cyber threat.
We have just done an exit interview within the last 5 hours regarding cybersecurity in our IT department. That information will be, I've shared that private and confidential information so far only with Kathy Dupuy-Bruno, because some of the areas that we are looking to protect come under a protected set of information. We are prepared to put a public statement forward regarding the audit, but specifically some of the cybersecurity measures that we would take would not be for public consumption. So the short answer to your question is yes, we have just done an exit meeting. There's other information that still has to be uploaded into the audit report before it's final, including some management responses as to how we proceed to deal with the recommendations that the audit made for IT and cybersecurity.
So the reason for my question is this our number one priority, to put our IT and IS staff through another audit? That's my first question. And then my second question about it would be, you talk about revisiting it periodically. what do you mean by periodically? Do you believe that this needs to be audited every year? Is this something that you would audit based on something that happens in the international world of cybersecurity, whatever? I mean, just like to know a little bit more about how you plan to do these audits.
Yes, ma'am. So I will speak as well as I can about the cyber threat intelligence. It's a team of specialists from RSM that actually executes those and the work with the ongoing, or the recently exit meeting completed audit that we are just finishing. To your first point about the timing, there are, at the risk of divulging too much information, there are certain things that I believe management is intending to do that would certainly impact the timing, could impact the timing of the cyber threat intelligence program development. And so I think certain consideration does have to be given there to where the district is in those efforts before this can begin.
Okay.
So I think that's a great point.
Okay, thank you. That answers the question.
Okay.
Thank you. Board members, any other questions? Ms. Patrica?
So that was actually my question. We share a brain, Ms. Morgan, because I thought I remembered somewhere in the recesses of my brain this audit already having occurred. I'm very encouraged to hear that particular attention will be paid to the confidentiality of the outcomes of that audit, because I'm not sure that we've always given that the attention that it deserves. So I appreciate that. And if I may, through the chair, direct a question to Mr. Cohen. Were you aware that we had just done an audit when the committee made this recommendation?
Yes, we were, but our understanding is that it was more of a general information technology audit with pieces of that audit covering cybersecurity. This one is a very in-depth cybersecurity audit, so it's very focused. The other one is a more general audit of the information technology environment. So that's why we felt a deeper dive into cybersecurity is something that we should be considering. We also did take into account the weight that's going to be borne by staff in having yet another audit performed of that area. But unfortunately, as everybody has seen in the media, everybody's under cyber attack. And the more controls that you could have in place, not saying that it would eliminate it, but it could hopefully curtail the extent of any potential exposure that the district would have.
So if I may ask Dr. Bernier, what's your sense with regard to the timing of this?
In regards to the timing, I think there is some flexibility from RSM's point of view as to how we adjust this as a priority. I think, to Mr. Cohen's point, while you can never be 100% sure in the cybersecurity world that you have all of the holes plugged, as a non-technical term, you have to do everything possible in order to ensure that you know that you're attempting to do all that you can. Without getting too deep into the recommendations that were made, there are some general recommendations made from the audit that we just had a sort of an exit meeting about before management responds to those recommendations. But there are some very specific cybersecurities there as well. And I think you would want to give the team some time to make sure they have made those adjustments and then take the deeper dive into IT. I agree with Mr. Cohen and RSM. This is an area that has to be consistently monitored. This is an ever-changing framework. There are people up right now somewhere in the world figuring out a way past your data systems. And we need to be doing everything humanly possible to do that. But again, with just not even officially closing the audit yet, but just having an exit meeting, I think the IT team could use some time to implement, especially in the area that Mr. Cohen is driving home a very salient point, and then have RSM in their ability to prioritize all these audits, make the determination of when they feel it would be best to come back. They've been working very closely with the IT team, and I think RSM has some viewpoints on this matter as well.
So is it the expectation that the board is going to approve an order in which these audits take place?
I suspected that RSM would have some form of recommendation today for you as one of their other employees, that they would make a recommendation based upon the audit committee's 4 hot topics, 4 big issues. And I agree with Mr. Cohen again, that there are other items on this list, and I think Ms. Vaughn just mentioned it as well. There are other items on this list that have merit and value. But if we look at the 4, we need to make some, I think there should be a recommendation moving forward as where we should start and where particularly some of these places and these topics fit within a larger auditing framework, both for RSM, for us, as well as all the other work that they're doing for other clients and other organizations.
Thank you.
Thank you. Ms. Jordan?
Hi, Matt, thanks for being here. Glad to see you. And Mr. Cohen, thank you for being here this evening. I'm already here today. Really appreciate you all. When Ms. Vaughn had asked that question, you only do one audit at a time, and then that's completed, then you start the other one. You're not doing it together. You're not doing 2 at the same time or 3 at the same time. You finish one, and then you move on to the next one.
So not
Correct?
So our recommendation, which we're prepared to kind of go over the timeline with the board today, would basically be not necessarily to start one and then finish it before the next one gets started, but to start them staggered. And then one may be in reporting phase while the next one is just kicking off.
Right,
and,
okay.
and so forth. So that it's not necessarily a clean break between one beginning and one ending, but that there's to get through them all in a period of time, right? So I think our recommendation, considering the discussions that we've had today, would be to start with going in the order that the audit committee recommended them, but with considering the timing of the IT, like we just spoke, would be to start with half-cent since it was second on their list. And I think we could be prepared to start that in late August or September if that was when the board wanted us to get started, which would look at, probably like a December finish, and then maybe kicking off contract compliance in November, right before that one fully concludes, which would probably be a January, February ending date, and then starting P cards in February, and then the cyber threat intelligence in January. Sorry, I went in a little bit out of order there, but
No, you're
starting
fine.
in January and then starting P cards in February. And the reason that those would really be concurrent would be because it's two totally separate teams from RSM, also from the district, that would be, responding to requests or anything related to both of those audits.
Great, thank you. And then also, I know Ms. Patrica had mentioned, before you do anything, you sent us the contract that's signed, and then you begin.
Right, and the
Just want to make sure
contract,
that that's understood.
yes, and the contract would lay out approximate start times like we've
Correct.
done in the past, and end times. That way, that's communicated up front. Everybody's on the same page in terms of, what the timing would be.
Perfect, thank you so much, appreciate it.
Thank you. Ms. Vaughn?
Yeah, I wanted to make a comment on the IT audit, even though IT is certainly not a strong suit with me. I realize that every day in the news, as Dr. Bernier said, there is something different going on. So my view of it is, if I were on that team, instead of looking at an audit, as some people here on the dais seem to think that it would be just a burden, so to speak, I would see it just the opposite, because I know the professionals that we have on that team certainly, with the fast pace of everything, plus the fast pace of us as a school and all the other services that IT has to provide to us to keep us running as a school district, that they would actually welcome another set of eyes, another set of professionals, because certainly, again, if it were me on that team, my greatest nightmare would be that something was missed, and something that just came up was missed. And, thank you to another set of eyes and professionals that are doing this, again, not to be a burden, but to be of service to all of us. So that's my take on it, a little different from what I heard from colleagues.
Great, thank you. Any other questions? Do you have more to present at this point?
Nothing from RSM to add unless you guys had any questions.
Okay. As I was looking at the Cyber Threat Intelligence Program Development Rationale, it seemed to me that you were taking some a closer look at the priority intelligence requirements and the cyber threat intelligence needs in order to prevent being threatened, I'm losing the word and I'm sorry.
Hacked?
Yeah, well, I guess that's a simple way of saying it, yeah. So was that it, as opposed to the audit that was done in IT recently?
Admittedly, this is a bit outside of my wheelhouse as well, but yes, as we've kind of discussed so far, what we were just wrapping up now was more of a broad look. This is a much deeper dive into a specific area.
Yeah, that's what it looked like. Thank you.
In answer to your question, there are 3 levels that you can pursue in information technology. You have the general information technology, where it's distribution of computers, landlines, etc. You have the cybersecurity, and then you have the most in-depth, which is what's called a penetration test, where they actually do try to truly penetrate the system and find the gaps within the system. Obviously, that's the most highly confidential report that will be generated, and that is one where you have to have a specific expertise in order to perform that type of audit. There are not a lot of people who have that explicit expertise who can do so, and that would be something that would be very eye-opening. It's eye-opening even to the federal government when they have penetration tests done, that they realize that they had gaps, and we're talking experts who sit in those capacities overseeing the information technology structure. So that's why there were actually 3 different levels. We did not feel at this time that we wanted to recommend the performance of a penetration test. That's a very detailed and very invasive type of audit, and especially since processes are now going to be put into place
Right.
pursuant to the information technology audit, we felt that the order would be going through the 3 different phases, with the penetration test most likely going to be a recommendation for the 2023-2024 audit plan.
Thank you for that explanation, and that was the word I was looking for, penetration. Okay, thank you. Any other comments? Then I guess we have no other questions at this time.
Can I get clarification, because I think you're going to ask me to work with RSM and Mr. Cohen and the Audit Committee. So if I'm not mistaken, some of our next steps are to meet with RSM, devise a specific standard, beginning with the halfpenny sales, still making sure that we do IT, but beginning IT in January, which gives them time to implement the recommendations made in this audit that is completing currently. So the Audit Committee gets their priority items still dealt with this fiscal year, maybe not in '23, as I think the committee hoped to do it in the fall, first thing out of the gate, but give that IT team time to implement what they want, move from halfpenny sales into contracts, start IT, and then finish with P cards. I think that's the order I heard, and that would allow us then to put contracts together and get them to the board. I'll leave it at that, yes.
Okay, because RSM will put the SOWs together for us and send those based on what their work will be. Am I correct, Matt?
Yes.
Yeah.
Yeah. And then they send that to us to be brought up to the board, so we will be able to agree upon that, to vote on
I
that.
want to make sure we're clarifying that, because sometimes I think we pass information, we're not always clear about how information passes from RSM to the board. In some cases, which led to some of the confusion, the information was being passed from RSM to the audit committee, and I think we've cleared up the staff members' obligation to then ensure that that's been shared with the board. But can we clarify how this scope of work, SOW, clarifying with you that that's what you meant? And how will that SOW come from RSM to the board so that the board members and the public are aware?
Well, in the past, it had gone to Kathy Dupree-Bruno, the attorney. She looked it over, and then it comes back to us. And Ms. Dupree-Bruno was going to,
In the past, that's how we've done it. The SOW is drafted by RSM. We review it, kind of go back and forth a little bit, and then eventually it does come to the board for review and then approval.
And if I may, in response to what the superintendent brought out, the only component to the SOW that the audit committee should have any position on would be related to the scope of audit. If we feel that the scope is deficient in any way, shape, or form, or most likely not going to happen, but potentially overkill, that would be an ability for us to come back to the board and recommend that the scope either be enhanced or reduced. And obviously, we will have a strong recommendation with support behind it as to why we feel that the scope needs to be modified. But that would be the only component. We will never touch hours. That's up to the board. We will never touch the fee to be charged by RSM. It is strictly the scope and whether or not we feel it's sufficient or deficient.
Excellent.
Thank you for that. We really appreciate that input. And thank you, RSM, for your work and for being back with us. We do appreciate that. So, seeing no other questions, well, thank you for being here. Did you have anything further, Dr. Bernier?
No, I just appreciate RSM, Mr. Cohen, the other members of the audit committee had the opportunity to participate for the first time as a non-voting member and sit in their last meeting. They are a very diligent group, very focused on ensuring that the recommendations they make to the board come from a position of great seriousness. They are a all-business committee, and I appreciate that about them. And I think we have an upcoming meeting, at least potentially with RSM, regarding the IT audit. Again, there'll be some needs for some shade regarding some of the topics, but look forward to participating in that with you and continuing to work with the committee. And thank you for the ability to clarify process. I just want to make sure that somebody on your behalf, which is me, has an eye on making sure these documents are processing and getting to the right people at the right time. So thank you very much for that opportunity, Madam Chair.
And thank you, Dr. Bernier. Okay. Thank you very much. We appreciate you being here.
Thank you.
Thank you.
Next on the agenda is a change order memo, and we have Mr. Scott Rickenbacker here today. Good afternoon.
Good afternoon, everyone. Let's see.
Thank you, gentlemen.
For the board presentation here. There we go. Good afternoon, board members. Scott Rickenbacker, Director of Construction, Superintendent Bernier, Mr. Dupuy-Bruno. This is your June 2022 change order update as required by statute. On the cover sheet, you'll know this is just a recap of all the things on the second sheet. You had $1.3 million in direct material purchase change orders in the June reporting period and tax savings of $77,000. Non-direct material purchases of $40,000. with an amount returned to the district of $40,944. Contingency adjustments were $96,799. On the secondary supplemental sheet, it gives you a breakdown of what all of these DMPs, change orders, and contingency adjustments were for. Are there any questions?
Board members? I don't think we have any questions, Mr. Rickenbacker.
Thank you very much. You all have a great day.
Thank you.
Thank you. Next on the agenda is LAMP name changing briefing. And presenting today, we have Mr. Clayton Simmons and Mary Grace Romo, the Director of the Early Childhood Learning Center.
All right, good afternoon, board members, Dr. Bernier and Attorney Dupree Bruno. I'm Clayton Simmons, Executive Director for School Development, and Mary Grace Romo with Early Childhood, Director of Early Childhood. And we are here to brief you on the name change process for the Lee Adolescent Mothers Program, otherwise known as LAMP. LAMP is a state-required teen parenting program that provides educational, health, and social services to teen parents and their children. Since we now have teen fathers participating, the current name is no longer representative of the program. So School Board Policy 9.10 provides the opportunity to choose a name that reflects all of our students who need the services provided in the teen parenting program as they enter parenthood and also work to complete their education. There is a name change process, which includes forming a diverse committee, seeking public input, briefing the board, and finally voting for a new name. I will now turn it over to Mary Grace, who will brief you on where we are in the process.
As you can see, we have a diverse group that has provided valuable input throughout this process. They include 3 community members, 1 parent representative, 1 student, 4 school employees, 1 state specialist, and 1 district representative. The committee is halfway through the name change process. The Communications Department issued a press release and name suggestion survey. A second survey was published to increase the amount of participation. The ad hoc committee reviewed the suggestions and selected 4 names to bring to the board for this initial briefing. The top name suggestions are in alphabetical order: Lee Teen Parent Program, Parent Education Program, Student Education Parent Program, and Young Parent Education Program. After today's briefing, a new press release and survey will be released. The public will be asked to rank the 4 names presented today in order of preference. The committee will meet to examine the rankings, and the board will be briefed on August 16th with the ranking results and a recommendation from the committee. And now I'd like to turn it over to Dr. Bernier for questions and comments.
Thank you, Mary Grace, and Dr. Simmons, we appreciate your work in this area. Board members, I really don't have anything to add. It's a pretty straightforward presentation, and look forward to hearing your discussion and providing direction for the team to go out and finalize a name change for one of our best programs in the county.
Great, thank you. Board members, any questions or comments? Okay, I have one question. I see we have one student representative on the committee. Was there interaction with more students regarding the name change? And did they have much input?
Yes, thank you. There was interaction with the students who attend the LAMP program, and there were task forces that got together. They did look at different name suggestions. They gave preferences. They talked about what certain acronyms might mean or not mean and their preferences for those things.
Great, thank you. Ms. Jordan?
Thank you for asking that. I was wondering that as well, because when I'm looking at this, I could not even imagine one student coming up with any of these names. So I actually went past this, didn't even realize that they were the names. So I had to go back when they said 4 names, because it just didn't, I guess I don't look at it as a program, even though it is a program. I'm thinking that it is a school in itself. So I was just curious about the student participation, because I know most of those people that were listed on there. So thank you.
Great, thank you. Anyone else? Ms. Bond?
Well, I know you described the process and the voting. Frankly, to me, the one-parent education program, that just doesn't sound like a real viable choice, because, you know, for people that are looking at this for a first time, I'm thinking like parent university, and it just, obviously, the young people at what is now LAMP are parents or parents to be, but anyway, hopefully other people will see that, and I think that's probably the PEP acronym for that sold that one, but I just see it as a really confusing choice for the program and school that will be associated with it, frankly. But the others are all good and viable choices.
What did the kids like the most?
Well, the students were very clear that they did not want the program to be named TAP. What they did like, as Mrs. Vaughn hit on, was PEP. They did like that, and they like STEP, the Student Education Program, which they would call STEP.
Great, thank you very much. I guess we have no further questions or comments, and thank you for presenting this. And the PowerPoint was excellent, thank you.
Thank you very much.
Thank you.
Thank you, team.
Okay, now moving right along. We have policy review pre-briefing. And we have Attorney Dupree Bruno and Tammy Scott, Coordinator for MTSS and Attendance.
Thank you, Madam Chair.
Ms. Bennett, go.
Going to wait for them to go ahead and load up the first one.
Yes,
While they're loading it up, good afternoon, board members and Dr. Bernier. Joining me today is Tammy Scott, Coordinator, MTSS and Attendance. Ms. Scott is a member of the Neola project team for the district and serves as the liaison for academic services. Board members, yesterday you experienced your first workshop with Neola. This will be the review process for each set of policies as we move forward with the Neola policy conversion. The first workshop of each month will be dedicated to policy review and will be similar to what you experienced yesterday. Once the bylaws are completed, hopefully by August 11th, you will then be reviewing policies that have been vetted by staff for your consideration. Neola will be at those workshops to help facilitate the discussion and answer questions. We anticipate 60-plus policies coming before you each month in order for us to meet our goal of full policy adoption by May 2023. During this process, the public will have an opportunity to forward emails as to their thoughts about certain policies or make comments at action meetings. The goal is for the bulk of the new policies to go to first reading in April, May, and second reading in May 2023 for final adoption. The public will have an opportunity to speak at that time as well. There are certain policies that will come before you for more immediate adoption because we do not believe it is prudent to wait until May 2023. Those policies will primarily be focused on laws enacted by the 2022 legislative session. Today, there are 6 of those policies that we are bringing forward to you for a pre-brief and anticipated first and second reading in August or September as follows. Proposed revisions to our current Board Policy 1.27, non-discrimination, which adds specific statutory language from House Bill 7. Proposed revisions to our current Board Policy 2.062, Parents' Bill of Rights, which adds specific statutory language from House Bill 1557. Newly created Board Policy 2.0621, Student and Parents' Rights, to be in compliance with House Bill 1557 and other laws. Newly created Board Policy 2.0622, Student Parent Complaints, to be in compliance with House Bill 1557. Newly created Board Policy 3.041, Curriculum Development, to be in compliance with various laws. And newly created Board Policy 3.051, Program of Instruction, to be in compliance with both House Bill 7 and House Bill 1557 and other laws. There are other policies forthcoming from the 2022 legislative session, some that will include additional provisions from House Bill 1557, such as parental consent or declination, opt-in, opt-out to health services and screenings, and parental access to student records. House Bill 1557, the Parental Rights in Education Act, and House Bill 7, the Individual Freedoms Act, are bills that elicit passionate responses from their supporters and detractors. The district is aware that both of these laws are currently being challenged in court. Notwithstanding, as of July 1st, they are the law in the state of Florida. We are keenly aware that some stakeholders believe that the laws do not go far enough, and some are gravely concerned about the impact of the laws on various issues relating to students, staff, teaching, and learning. In order to safeguard legal compliance in the implementation of these policies and related administration processes, the district will abide by the laws, all laws, to include House Bill 7, House Bill 1557, the Parents' Bill of Rights, and other state laws of equity and non-discrimination, federal civil rights laws, not least of which is the 14th Amendment of the United States Constitution that assures equal protection of the laws to its citizenry. With that said, at this time, board members, are there any questions on the proposed revisions to our current Board Policy 1.27, non-discrimination?
Board members? Ms. Morgan?
Yeah, so this is a lot to read, and I'm not sure that I comprehended everything, so my questions, well, maybe, anyway. On 1.27, I'm reading the non-discrimination for the collectively bargained, negotiated agreements, et cetera, but I see no reference to the Student Code of Conduct. And the Student Code of Conduct also has a statement of non-discrimination, I believe, and I'm just wondering if it ought to be included here.
If it's to the board's discretion, and well, we can add the Student Code of Conduct. We would have to vet that also through Neola, but I don't see any reason why we could not add Student Code. Tammy, do you see any reason? Okay.
Thank you. Ms. Vaughn?
Yeah, a question on that. I basically don't oppose it, but since the code of conduct essentially changes every year or every other year, is that something that we should keep in mind in terms of the policy?
We can add language that just basically references the student code of conduct, so as it changes, we don't have to change this policy. It's the student code of conduct that will change.
Okay, so it wouldn't be like, yeah, a particular year, even though the codes do significantly change?
Yes.
Okay.
Okay, thank you. Any other questions or comments on 1.27? Board members? Ms. Gittens?
The only thing that I would say is, for purposes of everyone understanding what we're doing here, is taking the law as it is and applying a policy as to how we will follow the law. And that's all that this is. We are not adding or detracting from the law. We cannot do that. It's the law. And as you can see, everything is referred to a particular law or statute. I guess, basically I'm saying if it says FS 76.10, we have to follow FS 76.10. Regardless of how we individually may feel about FS 76.10, we raise our hand at the beginning of our terms and say we will follow the law. And my statement, and I've said this before, that if there are things that people disagree with, then it's at a higher level than this level to change FS 76.10. That's basically what I have to say about it.
Thank you, Ms. Gittens. Ms. Jordan?
If I may, so Mr. Bruno, the red is is the addition to, because the other stuff is not struck out, so that still remains.
Correct.
Okay, so all of that we have the body at the top that specifies every single person as far as the non-discrimination, that stays there, and then this is just an addition.
Correct.
Okay, thank you.
Thank you.
So we will move this policy to the first reading. The next policy is a revision to Board Policy 2.062, the Parents' Bill of Rights. What is in red is what has been added, and this is as a result of House Bill 1557, Florida Statute 1001.42, subsection 8C. Ms. Fisher.
Ms. Patrica?
Yes, I'm wondering whether wherever the word parent appears in a policy, if we could add guardian as well. Because I think this applies to parents and guardians, and some kids bristle at the notion of a guardian being referred to as a parent.
So we can definitely,
That's a good point.
Tammy can add that. I do want to point out that when we finish our NEOLA conversion and we have our definitions, parent will be defined and that will be included, but for this purpose, we can add guardian.
And if we could just sort of keep an eye on that as we move through all of our policies, and ensuring that parent and/or guardian is included there, that would be appreciated. Please and thank you. I mean, some people don't really, never mind, I'll stop there.
Thank you, Ms. Patrica, Ms. Gittens, then Ms. Jordan.
Okay, so I have a question on the 2.062. The red is this is specifically the Parents' Bill of Rights. And what we are adding in the red, and I don't know if we can put that up, it is up on the screen. So what we are adding is just how we will not interpret, because that's the wrong word. We don't have to interpret it. We just have to do it.
Yeah.
Is that correct? So this is just basically saying what we will do to follow the law.
So last year, the legislature enacted Chapter 1014, which is the Parents' Bill of Rights, and the board adopted this policy as a result of that legislative change. This year, pursuant to 1001.42 subsection 8C, which is House Bill 1557, there are some things that we felt was necessary to add into our Parents' Bill of Rights, which is what is in the red. For example, on line 65, which is subsection C, we completely added the notification of parents, to parents, of any services or monitoring changes of a student's health, et cetera. This is specifically coming from the new legislation.
So that's just an addition based on the legislation. I guess what I'm saying on the beginning of this, like the first few lines, 5 through 7 or whatever, it's just kind of our preamble. In other words, if we didn't put that first part in red, it would just be 1014 and 100.42 without our portion in the beginning. Is that correct?
It is definitely a preamble, but it is a preamble that comes again directly from House Bill 1557. That is language from the bill.
Okay. Thank you. Ms. Jordan?
I was just going to say that I agree with Ms. Patrica regarding the parent-guardian, because we have many children who have guardians, their grandparents or aunts, uncles, someone else taking care of them versus a parent. And so to make it,
So we'll make a recommendation to the district's Neola project team that whenever that word parent, we'll put a parentheses there that includes all legal guardians, et cetera, so that from now on for every policy.
thank you.
Thank you. Okay, any other comments? Okay, moving right along.
And this policy at this point will move forward to its first reading. Next is Board Policy 2.0621. And this policy is a very comprehensive policy of many, many laws. We bring this forward to the board, and this is the policy, and you will see this. There are some policies.
Bless you.
Bless you. Thank you. There are some policies that are adding to our current policies. There's some policies that we're adopting completely new from Neola, and it's new to Neola as well. And then there are some policies that Neola has had in existence, but because of legislative changes, they've had to change certain things in their policies. Well, this is one of those policies. This policy pretty much has the kitchen sink of every single right that a student may have. We're bringing forward it to you today because it also includes very specific language in terms of House Bill 1557.
Thank you. Attorney Bruno. Ms. Gittens.
So, okay, this, Neola has had to adopt this because of the changes in the laws. Can you, and I'm sorry, your name again was? Okay, so thank you for being here, Tammy. My question is, how many, doesn't have to be exactly specific, but how many other districts, I know quite a few districts in the state of Florida have services of Neola to do their policies. And so how many of them that are your clients are affected by these particular changes that we are doing?
So, when Neola comes back, we can get the exact number, but if I remember correctly, it's over 30 districts in the state, if not more, in the state. So I don't have the exact number, but they have told us that number repeatedly. I just have not, I got a lot of other stuff on my mind, so I didn't retain that number, but it's over 30 if I remember correctly. So it's quite a bit of districts use Neola, and it's not only in the state of Florida. Neola is throughout the United States, so they service other states as well with this service.
But this particular Parents' Bill of Rights is Florida, though, so.
Yes.
So in the state of Florida, what do we have, 60-some?
Yes.
Districts? So half or so of the districts are using the services of Neola with the same verbiage?
Yes, pretty much. I mean, you may have a district that may change a word here or there. Some districts may not adopt a particular policy, but for the most part, everyone is relying on Neola for the most of the legal vetting, and then they come back, just like what they did with you yesterday, come back to the board and have a discussion, or their legal teams, once they are established, Neola customers will review the new additions to the policies.
Any other questions or comments? Ms. Morgan, I'm sorry.
Yeah, so attendance section A, which are lines 62 through 66. I don't think that reads very well, since we're putting process in these documents, which I think is great. But I'm trying to understand how a student can file a notice of intent that has to be signed by the parent, but the parent has the right to be notified of the receipt of the student's intent. So that suggests that the student can, independent of parents, notify the district. So that's not clear to me.
Thank you for your question, Ms. Morgan. Our process has it outlined in regards to if students age 16 or above and along with the parent. So, well, I just clarify, you can work on the wordsmithing
I think it needs to be clarified in policy, because that's what people tend to start with rather than the procedure.
Absolutely.
So, a couple more. Thank you for being patient, everybody. Okay. I didn't understand, so student records lines 451 to 454. I did not understand that. I don't know whether it's a grammatical sentence structure. I just, somehow I read this and I don't understand what it's trying to say. It's the right to challenge in hearing and right of privacy. What does right to challenge and hearing mean?
Hold on, Ms. Morgan, I'm looking at the...
Yeah, that's actually line, 451, 452.
Access and right to challenge and hearing of right of privacy in the education records. For records.
So this is relating to FERPA. Sometimes what happens is, a lot of times with custody cases where one parent is saying that I have custody, the other parent doesn't have custody, who gets access to the records? This is what this particular paragraph is referring to and trying to discuss. We can clarify the language, but that's really what it is. It's basically saying that each parent has equal access to the records, can waive access, they can challenge who can review the records, they have the right to privacy, etc. That's what this is referring to.
And I understand that. What I don't understand is the right to challenge in hearing, what that means.
And request a hearing. If there
That would
is
be the process in which we would follow if
Right.
a parent was...
Yeah, so that just needs to be
The words.
the wordsmithed a little bit. And I think I have one more. Student accountability and school improvement rating reports, line 479.
Yes.
Parents of public school students are entitled to an easy report card, or if applicable, school's improvement rating and the school's accountability report, including the school financial report. What is the school financial report?
Those types of reports are all accessible through our website for parents, the financial reports and everything.
By school?
The district's financial reports.
It says the school financial report.
So
Who was on that?
I think that's something that we're going to have to go back to the team with academic services and review this language just to verify in terms of school or district. I'm wondering if it has something to do with the internal accounts too that schools may hold. So I think we need a little bit more information on that one.
Okay, and thank you for indulging me, Board. I have one more question. Line 613, 614, sex offenses including rape, sexual assault, or sexual misconduct with a student by school personnel. What about another student?
Can you please repeat the lines?
Which line?
Yeah, it's lines 613 to 614. And it's talking about notification to parents of unlawful acts that occur on school grounds. It refers to sex offenses by school personnel, but it doesn't mention sex offenses by other students.
So that's a very good point. There is very specific statute that addresses sex offenses by school personnel. I will look into whether or not we can add students. There is a way for parents to be able to get information with regards to anything that happens to their child at school. I do know that this language is statutory, but let me look into whether or not we can add students to that as well.
Okay, thank you for indulging me. Those are my questions.
Thank you for your feedback.
Morgan, Ms. Gittens.
Okay, I'm going back up to line 78, 79. And to me, the wordsmithing is a little awkward when it says parents have the option to comply with school attendance laws by attending. Someone could take that and just kind of run with it. In other words, I can or I don't have to comply with school attendance laws. So maybe that part could be reworded, you know, as parents must apply or comply with the school attendance laws, this may be done, and I'm just speaking off the top of my head, but does that make sense? Do you understand?
Yeah, we can correct that. It's referring to attendance. You can either go to public school, private school, charter, but we can correct that to make that clear, Ms.
And I understand what it's saying, but it could be misconstrued that they don't necessarily have to comply. It's just a nitpicky thing, but thank you.
And I was planning to send you my Scribner's comments separately via email, copy the board.
Yes, and Ms. Scott as well, please.
Any other questions or comments on any of policy 2.0621? Ms. Gittens.
Chair, Attorney Bruno, this is first reading. When is the second?
No, this is not first reading. This is a pre-brief, so that the board has an opportunity to give us exactly what you have given us today, the feedback, so we can go back to our team and review the policy once more, and then as well as talk to Neola about some of these changes. And then we will have first reading, most likely will be in August, and then we will have second reading following that.
And when is the public involved in those particular readings?
So the first reading will be at a briefing, so the public will be able to provide comments at that point. And then the second reading, of course, will be at an action meeting. It will be a public hearing, and the public will be able to provide comment. The public has access to this on board docs. They can review it, and they can always send in emails if they have any questions or concerns.
Okay, thank you.
Thank you. Okay, I think we're good here.
Thank you. We'll move forward with this to first reading with the corrections. The next one that we have is Board Policy 2.0622, and this policy is directly from House Bill 1557. Ms. Morgan.
I'm sorry.
Ms. Morgan has her hand up.
Ms. Morgan?
Yeah, so since we are putting process in these policies, and obviously process was put in by the legislature, line 26, or 25 and 26, this process must be complete within 7 calendar days of receipt of the parent's written complaint. That is the process of the principal meeting with the parent. I do believe that the principal should be recording the results of the meeting. I don't think that should be left open.
Very good point, Ms. Morgan. There is a process document that the administrators will have that coincides with this, that's a little bit more specific in terms of from that point that you actually get that complaint from the parent all the way till the very end. So there is more specificity.
I understand that, but when a parent's looking at this policy, they don't see that there's going to be a written documentation of their complaint, and I don't think we should ignore that just because it's in the protocol.
Okay, so we'll bring that back to the team.
Okay, thank you.
Any other comments or questions on 2.0622?
If there's no other comments, then
I have one quick one, if I may.
Yes, Ms. Gittens?
On D, so is there a process paper that goes with this, or this is it? In other words, because it pretty much lays out when the parent notifies the principal, then the superintendent, the designee, and boom, 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 down the line. And if not resolved by the district, the parent may seek other remedies. Is there a process document, or is this considered the process?
no, this is the policy, the overarching that codifies the law in our board policy, and then there is a process document for the administration to use that goes step by step in terms of how this is going to be handled at the school site, when is it brought up to the district level, et cetera.
Is there a reference to that process document that if I were a parent and I got to this point and I wanted to know what happens next or what's going to happen, is there a reference to that I could say, okay, they're going to do this, 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 and this? Is it public record somewhere?
So I can tell you that as this process document is being developed and worked on, we have a draft, that there has been discussions about when to send a letter to the parent, et cetera. So at some point, the parent will know, the statute requires us to advise the parent in terms of what is happening. If we do not advise the parent within a certain time frame, it gets escalated up to the district level, and we have an obligation to advise the parent to either explain or resolve the situation, or there's a statement that we have to provide in terms of why this was not resolved. So there is, this policy is overarching, and there is a process document that is more explicit in terms of how this will run through the district system.
I guess too, what I'm saying, if I were a parent and I were deciding whether to move further to make a complaint or to follow up on a complaint that I made, my next step could be determined on, if I sit and look and see there's 50 more things that have to happen, I may choose another route. So that's why I'm saying to have it clearly in there, that if you make a complaint, this is what's going to go forward from that. And I'm not sure how to put it in there, but do you understand my?
I do. This is something that we can bring back to the team to discuss further.
Okay.
Thank you, Ms. Gittens, for the comment.
Thank you. Ms. Jordan?
Thank you. I keep rereading these over and over again. And I see on 14, within regards to parents' concern and complaints. So if I'm a parent and I call and give my complaint over the phone, it doesn't count? Or,
so
a lot of people don't want to email, or they don't want to put some things in writing, but they prefer to have that conversation of their concerns and the issues that they're having because they can express themselves better that way. So where does that lie? Because it looks like it's a statute.
So we can bring this back to the team to discuss further, but I will say that this is a formal process that's outlined in the statute that requires certain things. And this process also creates a cause of action. And either the parent can request an injunction or it can go to a special magistrate. And those rules just came out for the special magistrate in the Department of Education. So I would recommend that you not make a phone call if you're going to go through this and you want it to go through the formal process. It should be in writing. If you've already made a couple of phone calls and things have not resolved, then this is when this comes in, where you formally put it in writing, here is what my concern is, and that triggers the district to move forward with the process and the timelines that is necessary.
Okay, so this is for when you're taking the next step, not just if you have a concern or if you have a complaint that you want to share about your child's.
This really should be for significant issues that are related to House Bill 1557 is the way that the legislature wrote it.
But that's not what this just says, parents, student and parent complaints. So that to me is any complaint.
So we can clarify that. We can go back and clarify that. Thank you, Ms. Jordan.
Thank you, and Ms. Giovanelli?
Just to add to that, I think it's always best, it's kind of like the golden rule. If you have a problem, try to go to the teacher first. Yeah. Try to go, and then if that doesn't work, then you go to the superintendent, excuse me, the principal, and then you would come to the district. I mean, and I think most parents do that and try to get resolution at the school that they're having the issue. And I think if we just kind of help guide that, but I think the principals are going to have to say, if you really have an issue that we haven't been able to resolve, it has to be in writing to the district as a formal complaint. And I think if we communicate that, I think the understanding will be there. But, you know, I would always encourage, and I try to encourage parents to take it to the teacher, then take it to the principal. And, because, I mean, it's kind of the right path, you know? So I just thought I'd reiterate that. Thank you.
That's something, thank you, Ms. Giovanelli, that's something that we can definitely add. And perhaps, Ms. Scott, we can add that as a couple of first steps to our own process document as well.
Great. Ms. Gittens?
And may I just say to Ms. Giovanelli's statement, I definitely agree with that, because many times we hear things one way from one person and don't look into the situation and find out that it's really something simplistic. So, thank you for that statement.
Awesome. Thank you. Okay.
So this, we will go back to the team, work on this, and bring any revisions to the first reading. Next is Board Policy 3.041, Curriculum Development. And this is based on various laws.
Comments, questions, board members? Ms. Gittens?
Am I missing it, or is there a place that says what the process of selecting curriculum? I'm sorry?
That would be a different policy
Okay.
that we have not reviewed yet.
Maybe when that one is done, it can be cross-referenced to this one so that everyone understands how do we get the curriculum in the first place. Thank you.
Okay. Any other questions or comments?
So this one will move forward to first reading with no changes. And then finally is Board Policy 3.051, Program of Instruction, based on House Bill 7, House Bill 1557, and other laws.
Madam Chair?
Yes, Ms. Morgan?
Yes, so line 63 and line 236, both refer to efficient and faithful teaching. Now, I assume that came from the statute. I have no idea what that means. It might be helpful for that to be in the dictionary as well, because what does that mean? Teach efficiently and faithfully.
And what was the other line you said?
It appears twice, line 63 and then line 236.
Thank you.
And these questions may be a little, I don't know, rhetorical, whatever. Section B talks about, under required instruction, Section B talks about the emphasis on the 10 amendments that make up the Bill of Rights and how the Constitution provides the structure of our government. I was surprised they didn't include the other.
The other what?
Amendments. And then the following one, the arguments in support of adopting our Republican form of government as they are embodied in the most important of the Federalist Papers. Who decides what's the most important of the Federalist Papers?
And that is language directly from the statute.
I understand that, and I don't expect you to correct it. I'm just calling it out because I think it speaks for itself.
Needs calling out. Ms. Vaughn?
I'm going to jump out there and say that, starting with your question, Ms. Morgan, line 62, 63, this harkens back to scripted curriculum, and it harkens back to some things that innovative teachers rail against for the most part. If you're teaching efficiently, it means that the scope and sequence, when, if you're supposed to spend 5 days on the Second Amendment, for instance, you need to spend that 5 days, not 10 days, not 5 minutes, but does that make sense? Faithfully. I know that I could never, ever stay with just the little questions in a textbook or suggested things, and I think most teachers feel that way, especially those of us old school teachers that are used to teaching efficiently and faithfully to what we're doing without 40 teacher manuals. That, I see those of us nodding our heads when we had a little tiny one book to make suggestions. So this is what this is how I'm reading it, this is how I'm interpreting it, and so for everybody out there, there are going to be some people that are just thrilled that the teachers who are accused of indoctrination of students have to teach faithfully to these books, and people like me who, if Tallahassee auditors came to see me teach, would probably drag me out in chains. The end.
That might happen. Ms. Gittens?
First, I don't know how to follow that, but I will. You know, it's funny when you're saying that, I can recall in teaching, there's curriculum that's do, say, stand, sit, sing, clap, you know, all of that. The difficulty with that is, I'll give you a quick example. If I'm teaching about the pyramids in Egypt, and I've been there, and I've ridden a camel up to the pyramids, and I take 10 minutes or whatever to describe to the students the sounds, the smells, and what it looks like to walk up inside of a pyramid and what you see once you get up inside. And again, like you said, if just so happened that administration walked in when I'm talking about the putrid smell around the corner of the side of a pyramid, and they will look at my checklist as to where I'm supposed to be at 3:05. Are we at that point? Are we saying I can't enrich their learning by talking about my experience because it's not do say at 3:05? And I don't know, Superintendent, I know I'm putting you on the spot. What is your thought on that? I mean, is it that restricted?
I don't believe what you're describing is the intent of this piece of legislation. I think what you're describing in terms of being able to work an anticipatory set with a group of young people to get them excited about the pyramids, to show them pictures of the pyramids, to describe the heat and the sand and the grit and the camel that you rode in on, if that's what you chose to ride in on, I think is all within
That sounds kind of
developing
funny,
an energy amongst young people, an anticipatory set for what I'm assuming aligned to the standard of ancient civilizations.
Right.
That is more important to our instructional leaders and to our teachers, to make sure that we're on standard and that we know that we are teaching the standards of instruction. I do believe even with these new pieces of legislation, there is some academic license how I go about teaching the Constitution. There's an aspect in here on Holocaust instruction. There's an aspect of history of the African American within our culture, Hispanic American contributions to the United States, the study of women and their contributions to the United States. We have very specific curriculums, though, in each one of our subject areas that align with standards that are expected to be taught. How you approach that standard, there is still some academic license left. There are some areas of communication with our principals and our staff and our PLC work where we have to discuss where some new boundaries may lie. But there still is avenues with which to make instruction exciting and fun and engaging to our children.
Well, and I want to go back because this next question has to do with the last one we talked about, but is relevant to this. In 3.041, line 8, it starts on 7, as the educational leader of the district, superintendent shall be responsible to the board for the development and evaluation of curriculum. That question is because we have a set standard and clear curriculum that we are handed. So how do you evaluate? I understand evaluating the results of the teaching, but how do you evaluate the curriculum? Is that saying, you know, in Lee County, we've taught it this way and our students have not excelled, so we're going to change it? Do we have the ability to do that? And that may be a long-term question that you can look at later and discuss.
I don't think it's that difficult of a question. I think there are avenues where how we approach the standards outlined by the state will require different curriculum material in order to reach those. We may be working with a specific reading intervention, to your last example, where we are not getting the results that we expected. The first thing when you adopt a curricula for some curriculum or curricula for those types of efforts is you want to look at your outcomes. When your outcomes are not what you expect, then you go back and look at your inputs and outputs, and you look to see whether you're implementing a curriculum with fidelity. So that's what it means to evaluate a curriculum. Are we doing it, do we have the right materials? Are we doing it the right way? Are we implementing it with fidelity? Textbook adoption is part of evaluating curriculum materials and curriculum. We have a process by which we adopt textbooks, and we've outlined that for members of the board, and there are parents who serve on those committees. So I think it is relying upon the superintendent along with his team. I'm not going to settle in on every piece of curriculum we ever adopt one-on-one, but I will be monitoring what's done in academic services as we move forward to give our teachers the very best resources they deserve in order to meet the standards that they're required to teach.
So if we are getting curriculum, though, I'm almost done, seriously. If we're getting the curriculum based on the vetted list from Tallahassee, and they say, on this list, we have vetted these books, we've vetted this curriculum, this is what you can use. We in the district and our district staff decides off of this list, we are choosing this one. And as time goes on, you see that our kids are not learning as well as we would like. So you decide to get something like a reading program resource to help. Does that then have to become vetted? Or do our resources that we add to enhance learning and education in Lee County have to be vetted through the state?
They don't necessarily have to be vetted through the state, but there are state rules, regulations, and state law that say when adopting curriculum materials, they must be research-based. Going any further than that right now would be inappropriate for me because I don't think I have enough of the statutory knowledge. But you just can't pick up a curriculum off the street and decide to do it with your kids. There's a process by which you must be able, I think, first and foremost, to justify to this board why we would have an expense related to the adoption of curriculum materials. And the question you should be asking of me is, are these things research-based? Do we know they've been effective in other places if we're outside the primary materials of which the state does help provide direction in terms of adoption?
Thank you.
Board members, Ms. Patrica?
I'm not a teacher K-12, but as I read this policy, I didn't see it as being any different from the experience my children have had K-12 in this school district. I mean, you know, this is far more detailed than anything we've seen the state require of us before, but everything that's listed in here are things that my students have learned when, on the incredibly rare occasion that a teacher stepped outside of her limited ability to exercise academic freedom, and I want to say it's limited because K-12, it is limited, and it should be limited. Higher education, you have far more freedom when it comes to the materials you use and how they're presented. It should be limited K-12. On the rare occasion that that's happened, the teacher was swiftly addressed by the principal, and the problem went away. So, you talked about the Constitution. The way I read that is that the other amendments do actually impact the structure of our government, so they will be discussed. And I specifically remember my kids learning these things in their classes. So I'm not alarmed by this. I think it's by the state requiring us to adopt this policy, I think it's creating an issue that doesn't really exist. And we're really just formalizing what we're already doing. That's my opinion. I'm not trying to debate anybody. I'm not calling anyone out specifically by name or by board member or by their experience. I'm talking about my experience as a parent in our schools.
Thank you. Ms. Vaughn?
Yeah, what I'm going to say is, in all seriousness, that yes, these are the basics, the bare bones. And I would also add that these, by and large, apply to, let's say, U.S. history class. But if a student is taking advanced placement American history, it's going to be very, very different from this. So I don't believe that this is taken into consideration, because although I have never taught AP American history, I'm very aware, kind of teamed with people who did. And when you go down to section F, we are being, this is being very prescriptive and rather subjective. American history shall be viewed as factual. Okay, yeah, factual. There was a civil war, or a war between the states. There's decision-making, what you're going to call it. There were certain battles, and if you're in the South, the battles were called one thing. In the North, they were called another thing. There is, whether people want to admit it, yes, there's a factual basis, but there is a subjective basis to history, as there are subjective basis to whether you read the New York Times or the Wall Street Journal. You're going to get a story that's very different. Not as constructed, shall be viewed as knowable, teachable, and testable. Okay? What year was the Civil War? 1861, 1865. Who started the Civil War? Oh, now wait. There we have, if you're following what I'm saying, this worries me as an educator, and I know we don't have anything that we can change here because it's handed to us in statute, and I'm not debating the fact that the teachers should be teaching the basics from the textbook, but there are so many other things that can be brought in, not even paying for something. I loved Miss Gitten's
camel story.
That's wonderful, and to encourage students to bring in, so-and-so has toured Civil War battlefields and what they saw and what was depicted there. I know this is getting away a lot from what we're doing with this, but I just really want to make the public aware that in drafting these policies, yes, we need to follow the law, and yes, as a district, we will follow the law, but yes, this undermines critical thinking, critical reading. It undermines the critical reading of primary source documents. What did Jefferson Davis say? What did Abraham Lincoln say? Those are factual, but they're going to be real different. And so I know I'm getting deep into educational philosophy here, but I feel like it behooves us as a board, at least behooves me as a member of this board, to point out some of the problems and also the fact that they're not going to apply to our advanced courses, which are college level courses. That's it.
Thank you, Ms. Vaughn. Ms. Gittens?
Okay. I want to make a quick comparison. If you look at 127, lines 34 and 35, 127, 34, and 35, it says these are prohibited activities. And compelling employees and students to believe that members of a certain race or color or national origin, sex or whatever are superior, et cetera, et cetera. When you go to 3.051 that we're talking about now, lines 111 and 112. 111 talks about instructional materials shall include the contributions of African American society. Students shall develop and understand the ramifications of prejudice, racism, stereotyping on individual freedoms, et cetera, et cetera. So we are saying in one document that this will be taught, and in another document you're saying that it will not be taught a certain way.
Ms. Fisher?
Yes.
If I may?
Yes.
Good point, Ms. Gittens. I will advise that the statute that you're referencing would be House Bill 7, which discusses all of this, does have a notation, and it is in our board policy 1.27, that these prohibited activities, meaning those things that you were referencing earlier, should not be construed to exclude discussion of the concepts listed as a larger course of training or instruction, provided such training or instruction is given in an objective manner without the endorsement of the concepts. So neutrality is what we have been training staff on, to be neutral and objective when these things come up.
Thank you.
And Madam Chair, if there's no more comments, I know that we have other things on the agenda.
Yes, and I was just going to comment on the time, which is 2:44. Okay, any other comments on this policy 3.051? Okay, we can move
So
on.
then we'll move forward with this.
Yes.
There weren't any, I don't believe, changeable comments, so we'll move forward as is with the first reading. Thank you very much, Board. I want to thank Ms. Scott and Dr. Spiro and their team for going through this and putting this together and getting us up and rolling with Neola and these very important, what we call fire policies. Thank you, Tammy.
Thank you.
Thank you, Benny.
Yes, thank you, Benny. And now, we'll move on. Does anyone need a break? We go individually, I guess. We'll move on now to our Civil Rights and Equity Guide, and presenting for us this afternoon is Jessica Duncan, Executive Director of Student Services, and Chuck Bradley, Director of Positive Prevention. And welcome this afternoon. Glad to see you.
Well, while we're waiting, let me just make a comment. I was speaking to a constituent the other day. Amongst the other things we talked about was the work that was done on this particular project. And she is very smart and very articulate and is used to throwing punches when it comes to the way the district processes stuff. And she said to me, I have to tell you that Mr. Chuck Bradley did a terrific job conducting the sessions. So I wanted to pass that on. So, thank you, Mr. Bradley.
That too.
Me too.
Yes.
Thank my partner here, Ms. Duncan, as well. We tag teamed very beautifully in leading those. And also, we want to say thank you to the multitude of people that have been involved in producing this, getting this ready. It goes back to, we've been working for more than a year on this particular document. And we want to say thank you to Mr. Jared Eady, to Ms. Kathy Bruno, Mr. Ryan Hudak, Ms. Christy Schroed, who is no longer with us in the district, and many, many others that have helped along this journey, including the student services team who helped to facilitate the meetings that were held and have helped with the logistics of this along the way.
Thank you, Mr. Bradley.
So, Dr. Bernier, members of the school board, Madam Chair, we're pleased to bring to you today the SDLC Civil Rights and Equity Guide draft. This is a final draft version for the year 22-23. Today's presentation will provide an overview of the major components of the SDLC Civil Rights and Equity Guide, the legal and policy basis for the guidance, the process for development, and anticipated steps toward completion. We included a bit of the compelling why for this document. It follows that civil rights guarantee equal opportunities, and that to achieve this, we as a school district must respond and must ensure that all students are provided equitable access to their education.
So this guide talks about the application, but we want to start with just an overview of the policy. So we put up here Board Policy 1.27, which is our non-discrimination statement.
With that, this guide draws from multiple sources of law that guarantee student and parental rights in education, including the U.S. Constitution. We must recognize that all civil rights emanate from the 14th Amendment of the U.S. Constitution, which requires the equal protection of the law. Parents' rights, which include our district responsibilities to honor parental rights as designated in Florida Statute 1001.42, which was amended by House Bill 1557, as well as Florida Statute 760.10 and 1000.05, which was amended by House Bill 7. We also recognize and utilize Florida civil rights laws and equity laws as found in our state constitution and statutes.
So with this triangle here, we want to express the importance of the teacher, student, and parent working together. And with House Bill 1557, we recognize that parents have a fundamental right to make decisions and be involved in the upbringing of their children. So the parents are an integral part of this triangle, and we just wanted to give that visual representation.
With that, we'll begin an overview of the sections of the Civil Rights Guide. It is organized by federal title laws and other civil rights laws.
So what we'll do is we'll briefly go over each title and give an example, and then if you have specific questions from your reading or the documents that you have, we can take some time to answer those. So the first one we'll be looking at is Title II. Which is non-discrimination based on religious beliefs and exercise in public accommodations. So the educational application, one of them is that students may bring personal religious texts to school and read during non-instructional time. So this means they can read during lunch. If they are in class and they're done with an assignment or a test, they can read. And the same goes for staff, who may also bring religious text and read during their lunchtime, their breaks.
Title VI is a broad equity law which requires non-discrimination based on color, race, ethnicity, and national origin. And an example of the guidance that's provided in this area includes that students and staff may speak or write in any language dialect when not engaged in instruction or a schoolwork task that requires standard English.
For Title VII, non-discrimination in employment, which includes a complaint resolution process, the educational application would be an employee cannot be hired, fired, promoted, or not promoted, disciplined due to race, color, national origin, sex, including pregnancy, sexual orientation, and gender identity and/or religion.
Title IX is another broad equity law that requires non-discrimination based on sex, including sexual orientation, gender identity, and gender expression. And an example of the guidance that is provided here, we anticipate that we'll be talking about this particular section most of the afternoon. But a particular example is the bullying and harassment and sexual harassment. And this, I hope, will answer one of our board members' questions that came out. Bullying and harassment, which is bullying harassment targeted towards a person for no other reason, is covered under the Jeffrey Johnston Stand Up for All Students Act. That is Florida Statute 1006.147 in the state of Florida, with a very specific process. Sexual harassment is covered under Title IX and has, again, a very specific process for the investigation and the resolution of that complaint.
And then we go into the Americans with Disabilities Act, known as ADA. So this is the umbrella over both 504 and the Individuals with Disabilities Education Act, known as IDEA. And with 504, this provides accommodations to students, so if they need something like extended time, they would have a plan written and they would be provided that time. With IDEA, one of the applications would be specialized instruction. So this might be where a student has an individualized education plan or their IEP, and in that they might get speech and language therapy, occupational therapy, physical therapy, or some other type of related service.
We also include several other non-discrimination laws, particularly pertaining to employees. Age Discrimination Act, which requires that we do not discriminate against employees once they hit the age of 40. So I think most of us are protected up here, I think.
Speak for yourself.
The Genetic Information Non-Discrimination Act, which prohibits the use of genetic information to discriminate against a person in employment or health coverage. And finally, the 14th Amendment. As we mentioned at the beginning, this is the Equal Protection Clause of the U.S. Constitution, which requires us to apply all laws equally to all persons.
Just wanted to share some of the groups that we worked with. Chuck did give a public thank you of sorts. Also wanted to just share that one of our community members had talked about the importance of civil discourse, and we feel like these meetings were such a great example of people with different views coming together in a positive and productive manner to really increase each other's mutual understanding of how they viewed important topics. And I just want to especially note our student group, which was phenomenal, and we are certain that we saw several future community leaders in that group, and their insights and suggestions were just invaluable. In fact, one of the parts of the document is the part where if you have a concern or a complaint, and one of their suggestions was to put a link to that under each section, which we did, to make that accessible to people who did have a concern.
So our anticipated next steps for the use of this guide, we do have our nuts and bolts meeting that is coming up in just a few days with our administrators. We do plan a presentation to our administrators. We will also be providing training for all employees on and the district through a video-based training program that will be provided to our school equity coordinators. They'll be trained in how to implement this guide and to utilize it in their work. And we'll also be working with our equity coordinators and school administrators to provide that training to their staff at school. Throughout the year, we anticipate that we'll be providing ongoing supports and trainings to these groups and to others, and also on-site technical assistance when needed.
Thank you, Mr. Bradley.
I had no,
Superintendent Bernier?
Madam Chair, thank you. I had no comments at the beginning because I wanted them to get right to the matter, but I do have a couple of points of privilege I'd like to say. First of all, thank you to Chuck and, excuse me, I'm fighting something in my throat. I just delivered a cough drop. Jessica Duncan, their work here has been amazing, but I think the other important factor for us to think about and talk about a little bit just briefly is that this is another example of how we can utilize our community and community engagement. That list of people that they listed, from students all the way through to the other organizations, some members of the committee are present even here today. I can't tell you how much I appreciated the time and the extra effort that you put in, not just the two individuals seated in front of us and the staff that they represent, but all the individuals who gave of their own time to come in and participate in what was, at least initially, a difficult process. I mean, there have been some wounds in this community surrounding some particular issues, and the idea of locking everybody into a room again and talking about diversity of opinion and working towards a solution for where we could be now may not have been the most popular suggestion that a new superintendent ever came up with. But I thank these two people in particular and the staff and the community they represent for taking on the challenge and really working in an open forum and making sure that the issues that we needed to move forward in order to get to a civil rights and equity guide came to fruition. Let me also be clear, and I know this will, I've checked it with both Chuck and Jessica, they will not leave over this statement. Our work is not done with this guide. This is an avenue and a manner and means which has to be consistently revisited, has to be looked at as laws within the land change. But I am most proud that this is a guide that aligns to the law, which is the most important thing we are all responsible for as constitutional officers up here. But it also responds to the need of a community that a parent has a strong voice in their child's education and their rearing. So I appreciate the work and the delicate balance. You're making it look very simple this afternoon, and I want you to know and understand and respect that all of us up here know how difficult for every member who's present today on this committee who came to this, create and help create this document, that nuanced work was more difficult than you're making it seem at this very moment. So I'd be interested in the board's questions and discussions as it relates to the guide, and look forward to a robust conversation between ourselves, our two colleagues, and some public comment that I'm sure we'll get at the end of this process.
Thank you, Dr. Bernier. And I'll save my comment for later. Ms. Vaughn, then Ms. Gittens.
Yeah, I just want to add to a little bit to what was already said. I was very interested in this topic, and so I observed two of the sessions, and when I walked into the first session and looked around at the community participants, I found that I actually knew a great majority of them, and in knowing them, I had not really trepidation, but I was thinking, oh, this is going to be fun, because I know that it worked out perfectly, that there really was a balance of people on both sides. And I want to reiterate what already was said. Both Ms. Duncan and Mr. Bradley did an excellent job. And I think it helped that they provided some good snacks, because, you know, people get a little grouchy when they're hungry, and thinking about the time frame that people were meeting, a lot of people probably came directly from work and didn't eat or hadn't had dinner. So I think good snacks really helps people from getting grouchy. And there was great participation, and people were paired at different tables to discuss. And yeah, I didn't see any bruises or blood or anything. No, everything really went very smoothly, and was proud of everybody that was there. So if there are any problems with the guide, it's not from lack of hard work on the part of all of the people that participated in organizing this.
Thank you, Ms. Vaughn. Ms. Gittens?
Well, I was fortunate enough to sit in like a fly on the wall. I didn't participate. I know that was hard, and Attorney Bruno kept looking at me. No, but it was, to me, that I was at the last one, and it was so funny. It was like the last day for seniors in high school, and everybody, when you said it was done, they're all just kind of like, okay, what do we do now? We want more. We want to do something else. This just couldn't be just the end. And that was what was so good about it. You know, left them wanting to be more involved and wanting to add more to it. And when I used to teach high school, the first week I was always do a lesson on respect. And I'd play the song, you know, and all this stuff, and the kids would get into it. But we would talk about the word respect. And I think the power of what was done in those sessions was a microcosm of what we can do throughout the district to show that a group of people with different beliefs and thoughts and opinions can come together and have respect for each other's opinions and thoughts and beliefs and come out with a product that represents all of them. So thank you.
Thank you. Any other comments or Ms. Jordan?
I would just say I've had a lot of conversation lately about this whole topic, but I really want to thank the committee who has that are here actually in the audience and that participated and gave of their time to be engaged in this. And I thank you, Ms. Duncan and Mr. Bradley, Mr. Eady, everyone that was involved in this. And keeping in line with what is best for our students and making sure that we are keeping in line with our non-discrimination policy and just working off of that so that each and every child knows that they matter.
So, great, thank you. Any other comments? Ms. Patrica, then Ms. Giovanelli.
So I've got several questions, and I think that you attempted to answer one of them by referring to Title IX. But the latest guidance I've seen coming out of the DOE on Title IX refers to gender-based harassment, and it doesn't call it sexual harassment. It might seem like a distinction without a difference, but if I get notification from my school that my child is engaged in sexual harassment, that means something very different from my child is engaged in or has been accused of being engaged in gender-based harassment. So I wonder whether I could get some clarification as to exactly where in Title IX we're finding that sexual harassment includes gender identity.
Sure. Well, the Title IX guidance that has been provided through executive order by President Biden does include gender identity, gender expression, sexual orientation under Title IX, and it follows along the Bostock ruling. I'll let Kathy explain in more detail if we need to go that much further. We're applying specifically, we're still under the DeVos regulation on the application of Title IX. The new proposed guidance for Title IX has not gone through rulemaking and it has not become effective at this time.
That doesn't answer my question, I'm sorry. Why are we referring to it as sexual harassment instead of gender-based harassment?
So right now, the actual rule that is in place does talk about gender identity and sexual orientation. In January of 2021 and March of 2021, President Biden issued 2 executive orders that were very specific in terms of non-discrimination based on sexual orientation and gender identity. And in those executive orders, he directed that all of the government agencies go back and look at all of their policies and processes to ensure that they were in compliance. The Department of Education then, I believe it was in July of 2021, went ahead and issued their guidance, now applying Bostock to Title IX. So Bostock was a United States Supreme Court case the Title VII case. So just for the public and the board members to understand, Bostock was a United States Supreme Court case where an individual filed suit claiming discrimination based on gender identity. And then the court said, no, you cannot discriminate based on Title VII, which is a different title, Title VII, based on sexual orientation or gender identity. From that was extrapolated that now this applies to Title IX, which is our sex discrimination. So then Biden issued those 2 executive orders. Then the Department of Education applied and said, okay, we're going to clarify at this point the application based on Bostock of Title IX to sexual orientation and gender, again, based on what the president directed them to do. So that's where we are now. And they issued a friendly letter as well to educators to advise them this is how we're going to apply. And they said that we're going to enforce this in the OCR process. If a student is feeling that they are being discriminated based on their sexual orientation or gender identity, we are going to enforce this. So where we are right now with this is that there is a case that came out in Tennessee where 20 states filed a lawsuit basically challenging really the rulemaking of this particular this rule from the Department of Education. So at this point, I believe it was about a week and a half ago or so, about 2 weeks ago, where that court did rule that they're going to enjoin the application of that Department of Education's recommendation regarding the application of Bostock to Title IX. However, it does not apply to the state of Florida because Florida was not a party to the action. And in the memorandum that was issued by the Tennessee court, it indicated that it would not apply this nationwide. It would only apply it to the states that were parties to the action.
So I know all that, but what I'm not hearing is where in the law sexual harassment is defined to include gender identity. Harassment on the basis of gender identity. Again, it may seem semantic, but legally they are 2 different things. And as a parent, getting a call from a principal who says your child has been accused of sexual harassment, that's different from your child has been accused of harassment on the basis of gender identity. There's a big difference between those 2. And so as we look at the guide on page 6, I think it talks about bullying and harassment, but investigating for sexual harassment when a child is bullying another student on the basis of gender identity.
So we should be investigating for harassment, period.
Right.
Okay,
And that's what Title IX requires. Now it is, I mean, regardless, we should be investigating. Going back to your original question in terms of gender identity, that is specifically coming from the Bostock decision. And then that was applied, as I said, through executive orders by Biden, and then the Department of Education adopted it, specifically adopted it and made a ruling. So if you even go on the Department of Education's website right now, that's what it talks about, sexual orientation and gender identity.
So why are we calling it sexual harassment?
So if I could jump in for just a minute.
Yeah, please, Jeff.
Title IX does include, again, it's very broad, in any kind of discrimination or harassment based on sex. And so anything that falls under that umbrella comes under Title IX, or possibly comes under Title IX.
Right.
There is a threshold, and so it does include egregious sexual harassment, the type that would run even into a criminal charge. When it falls into that arena, it's still under Title IX, but it may go into a legal arena for pursuit by law enforcement, et cetera. The type that we're dealing with in our schools can run the gamut from slurs that are of a sexual nature thrown at a student. It can include such things as inappropriate touch or inappropriate suggestion for sexual favor. When we find it so offensive that a reasonable person would see it as offensive, then it would fall under Title IX for the investigation model. And the guidance that is provided here is to distinguish between the two models that we investigate under. We have a bullying and harassment investigation model. We have a Title IX investigation model.
Maybe I can get with somebody offline because the question that I have in my mind has not been answered by the statements that have been made here today. I don't understand why we're calling it sexual harassment, but I don't want to belabor the point here in front of everybody.
Just one question. Can you tell me again where? Because I'm trying to find.
Page 6, where it talks about bullying and harassment.
Which block are you looking at?
I don't know.
Bottom one on the right.
It's block 1,
Block 1?
continued over to the second.
Oh, I see. Okay. Thank you very much. I see. Thank you.
Okay, do you want me to continue or do you want to move on to somebody else, Madam Chair?
You may continue.
Okay, so for names and pronouns, I think I'm still on page 6 of I'm on the guide, I'm not on the presentation staff just gave. Page 6, names and pronouns. Students under 18 need parental permission, correct?
That is
Okay.
correct.
And then, moving on, what is a consistently asserted gender identity for staff? I know the answer, but is legal documentation required for that? And if not, that seems to be inconsistent with the guidance that we have for Title VII section, the Title VII section on page 5.
That section talks about the court, when you legally change your name in court, where the section on page 6 just talks about the use of names and pronouns, not necessarily with a legal change through a court system.
Okay, so we are not requiring a legal change for staff to refer to them by names other than the one that's on their application or any of that. We're just allowing the consistent asserted gender identity. Why is there that? Why is that not consistent?
They're two different things. One is when a person has an affirmed name that they choose to use, but they're not making a legal change on documents. And then there might come a point where that person that wants to legally change their name, and then they do that through the court system. But there are individuals who are going to use an affirmed name who don't make a legal name change. So there's two different ways that they can do that. They can use informally a name or a pronoun that is their affirmed, that with their consistently asserted gender identity, or they can make a legal change of name through the court system.
Okay, and that's adults, right? That's our employees. Okay, and then GSAs, are we allowing the creation of GSAs at every level of education? I know the answer is no for elementary, but middle and high, it's my understanding that we have to allow the creation of a GSA at a middle school because they offer high school level classes, right?
Wherever we allow student interest clubs to be created, then we must allow for GSAs to be created at those schools. So that's in our secondary schools, middle and high.
So if we have a chess club in elementary school?
Usually that's going to be staff-led.
Okay. And what about K-8s?
Our K-8 schools operate as elementary, middle. So this would apply to the middle school students within a K-8.
Okay. Page 7, privacy under Title IX. What if a parent asks? And I don't really know what that means. I'm going to go back and look at page 7.
So basically, if a student discloses to a staff member their sexual orientation, gender identity, the staff member will let the student know at that time that if your parent ask me, I will have to inform them.
Okay, thank you.
And I can, if I may, Madam Chair, just to add to that, it's not only if they ask me, if there is a change in the service or monitoring of the student that affects their physical health, mental health, well-being, emotional health, parents will be notified.
Yeah, we just did that in the previous.
Right, I just wanted to make sure that was clear.
I do have a question about restrooms and locker rooms, but I'll leave that for later. For proms and dances, can we add that the active gender support plan has to be signed?
Yes, we can add that.
Thank you. And what are we doing if a gender support plan is not signed by a parent or a guardian?
Then it would not be implemented. We would not be providing accommodations on campus, but we would also balance that with non-discrimination for the student.
What does that mean?
Means we will not discriminate against the student
Right.
on campus.
Okay. Well, we wouldn't be doing that anyways, right?
Correct.
May I continue, or do you want to?
Let her, you can, why don't you finish?
Okay.
And then,
I was just going to say, are we going to, I had comments about prom. Are we going to, how are we organizing this?
okay, well, until now, there hasn't been very much, but if you, since we're just.
I'm happy to wait,
Yeah,
because I
yeah.
heard Ms. Patrica
Well,
talk
Ms.
about
Patrica,
prom.
is that okay with you then if Ms. Vaughn gives her comment
Yep, you're the
about-
chair. Yep.
Okay. Since it's
okay,
about we're on proms and dances.
Yeah, my comment here is, and I know this is not going to be popular, but I'm going to say it anyway. Students desiring to run for prom king or queen, when not consistent with their birth sex, must have an active gender support plan. I'm picking on homecoming and prom king or queen. I find electing a king and queen to be extremely outdated and sexist. I was looking online just a few minutes ago, and I see that there are a number of colleges that have moved away from that, and there are high schools that are also. Now, what do they do in lieu of that? There's some things, instead of using gender-specific titles such as king and queen, they use titles perhaps such as royalty, or they drop a king and a queen and just have a general homecoming court, which I know traditionally the court is they have the prince and the princess, and you know, I know in the South, especially with Parade of Light and all of that, the idea of having little princes and princesses and kings, and you know, it's fine for like Disney princess, whatever. But by the time you become a young adult in high school, I would actually say that we should consider as a district, and maybe some of the schools have done that, getting rid of the sexist titles such as king, queen, prince, princess. And I'm not sure that this whole sentence, and I know we can't do that here and now, but this whole sentence, students desiring to run for prom king or queen, it's sort of clashing with the whole idea. I'm just curious what my board colleagues feel about this. I know I'm on the liberal end of the spectrum, but I find it very outdated, I find it sexist, and I find it not in keeping with what we're saying about proms, dances, and that would also be homecoming, which of course has a dance.
So this was actually brought up by the student group as well. And I think these are one of the things when we talk about our ongoing work. I mean, we weren't at a point with that group to move forward, but when we talk to the principals, we are going to recommend that they start looking at those things. And then as we continue that work, might it be something that we look at district-wide? Yes, but it was actually the student brought up the same suggestion of using a term like loyalty.
Okay, and let me ask, what, from the since you've already discussed this, and, you know, at some length anyway, with principals and students, what seemed to be the, you know, the other thing with this, of course, is the popularity contest and all of that, but I'm not even looking at that because it will still be a popularity contest. Just what seemed to be, is it so deeply embedded that people are, including students, like, no, we have to wear a crown, you know, or what have you found in speaking with?
I don't know that we found any one thing, but the students did go back and forth within their group about the importance of those roles in the court and the need for inclusiveness. So there wasn't any definitive action or understanding. They just put it out there as something they'd like to think more about. And I think that's something, as we continue this work, that we need to keep on our radar. Our student group was one of the ones that we met with more recently, so it didn't come up with the principal group. So we'll bring this back around to the principals on Thursday, and then start that continuation of that discussion.
Well, and as I said, I know that this can't be decided right here and now, but what we are looking at is the verbiage, and personally, I'm not sure that, you know, the sentence, students desiring under proms and dances, whether that sentence needs to even be there. That's what I'm bringing up for thought.
One of the things we just wanted to make sure is, in this particular situation as is written now, that there's not a circumstance where a student is put up for a king or a queen where they are essentially outed or not in agreement, or they don't have their plan. So we wanted to protect against that as well.
Well, to be frank, I can see where some mean kid would try to out somebody by suggesting a shy young man in the class be put up for queen, but that should never be publicized, and that person has to accept it. You can't just, because kids in high school are mean, and you can't just put people up like, I mean, I can see people doing something like that, and it has to be accepted. So with all due respect, that's my opinion on it. And you know, personally, since you are asking about the verbiage, this would be something that I personally don't think needs to be here. And that's all I have to say about that section.
Thank you. Okay, Ms. Petrucci, you want to continue?
Yeah, so first of all, I haven't said thank you. I know you guys have put a tremendous amount of work in this, and I will tell you that when I read this, I felt so much better than where we were before because of the level of parental involvement and parental permission now needed. That being said, and this is not a question that I sent to the superintendent ahead of time, are we still in a position as a district where if we, meaning you, in your professional judgment, believe that a child is in real danger of abuse by their parent, should they go home and reveal this information to their parent, are we in a position where we can act on behalf of that student to protect that student?
Yeah, yes, and that is included. It's actually on page 7 under the privacy block, where if we believe, and we have more than just a hunch, but we have some real belief that the student is going to be subjected to abuse, neglect, or abandonment, we're required to protect that child under law.
All right, because I know that that's a real life issue for our kids, and I want to make sure that that's protected. Sorry.
Yeah, I think.
Thank you.
Madam Chair, if I could just add to that as well. House Bill 1557 is very explicit about that as well. It says that you do have district the responsibility to advise the parent. However, if you suspect that there's abuse, neglect, you must contact the authority. So it's in that bill as well.
All right, good. And, you know, my son going to you and saying, my mom's going to kill me if I tell her, that's not real. Okay. All right, turning to the gender support plan form. It states, and I quote, "If the parents, guardians are not aware and/or supportive of the student's gender status, how will homeschool communications be handled?" I'm not clear on how we can have a gender support plan form that's not signed by a parent and how that is not already being communicated at home.
Sure. And again, this is an older form. This is
Okay.
a form that was provided by Gender Spectrum several years ago.
Okay.
So we can certainly update the form. But as the family works through the form, they may not answer some of the questions as well. They only answer the parts that are pertinent to that particular situation.
All right, but there's not going to be a circumstance, unless it's one of abuse, where this gender form is being worked on with school staff and a student without the parent being aware.
Unless there's a custodial situation through a court that indicates something like that, and then in that case, that they would just go past that part.
Understood, okay. And I think I've already asked this, gender affirming name form, nickname form, both have to be signed by the parent.
Correct.
And then did you see my note about the opt-out for health instruction and how difficult that language was to understand? I read it 5 times and I was still like, what does this mean?
And we'll take that comment and refer it back to our curriculum folks to take a look at.
All right, and then you saw my comment about the glossary as well, and that's a Scribner's thing. I'd like to go back and allow people a second round because I want to talk about locker rooms and bathrooms, and that's going to take some time.
Okay. Board members, any other questions or comments right now? Ms. Giovanelli? And I'm sorry.
So I don't have a lot actually, but one of the things I did notice is the Hope Scholarship. I don't see a link there or anything for parents to be able to access that. I talked to a lot of parents that nobody mentions the Hope Scholarship to them, one within the last 24 hours. So I don't understand how what happens, and that communication is not conveyed back to the parent, but I think that's really important because our first avenue would be to move them to one of our public schools before going to a private school or them asking for that help. And the parent I just spoke to was unaware of it completely. So, but this has been a while that this has been an issue. This is not something that just happened recently. So I would like to see a link or something to that, giving them more information. I realize that you have the information here, but maybe a link for the actual application maybe, and what the Hope Scholarship actually affords them. If they were to try to go to a private school especially, I think that's probably the real question of the day. Because that seems to be a disconnect there. Not everybody seems to accept it, or they're full and they don't want to have to deal with that. I don't really understand that red tape there. It seems to
We
be.
have to add a link to the main webpage for Hope Scholarship, and on that page, parents can find information about how it works and which schools participate.
That would be awesome. One of the other things that I was curious, do you anticipate doing this same process again next year? Because who knows, the law could change again? Because it seems to be a moving target, and so.
Well, I think one of the things both Jessica and I, and we shared this with Dr. Bernier yesterday, that we thoroughly enjoyed working with our community. We have bonded, and we actually were kind of sad not to have another meeting. So I actually would anticipate that we will probably come back and revisit and invite our community to come back and re-engage.
I like that answer, so thank you. And that's really all I have for the moment, really was just the Hope Scholarship portion of it. Because, I mean, people think it's just one way, but it could be there's other schools in Lee County. Crestwell is one of them that would take a very diverse child, and they have those students and that excel there. So I would want to have the opportunity for both for any student, period. So, thank you.
Great, thank you, Ms. Giovanelli. Any other comments or questions before I revisit Ms. Patrica? Okay, Ms. Patrica, bathrooms.
All right, so I don't need to ask the question because I know the answer. If we have a student who is a biological female who identifies as a male and wants to use the boys' bathroom or locker room, the legal interpretation or the legal position of this district is that we will work with them on a case-by-case basis, and we will encourage the use of a neutral facility, but if the child and the parent insist upon use of the bathroom and locker room that coincides with their gender identity, we have to allow them to use that facility. Is that an accurate statement?
Ms. Bruno? Mr. Bradley?
So it's a difficult statement because where we are with the law, right? It's very unsettled at this time. We do not have clear guidance from the 11th Circuit regarding what to do about youth using a particular bathroom. There's just, at this point, the case that did have a ruling on it, I believe it was in 2021, Adams versus St. John's, has been vacated, and we're waiting for the result of that hearing. What we have now is the Grimm versus Gloucester case, which went up to the United States Supreme Court, and in that case, it was a Virginia case, 4th Circuit. That case basically stood for the proposition that a transgender youth who was insistent, consistent, persistent could use the bathroom that they identified with from a gender perspective. That case went to the United States Supreme Court. The court declined to rule on it. So that is really the federal law that we have now until another circuit decides to move forward, or the 11th, in terms of being persuasive. It is persuasive from a federal law standpoint. And then the only other thing that we have is the Department of Education's guidance. So that's the basis that if a student requests to be able to use a bathroom, and let's make sure that it's very, very clear. It is not a student that one day decides, I'm going to use the girls' bathroom. This would be a student who has requested accommodations through a gender support plan that has been signed off by the parent. This student has exemplified insistent, consistent, persistent gender identity, and they are requesting that accommodation. So based on where we are right now with the law, case-by-case basis, encourage a neutral bathroom, but if they insist, that will be the bathroom that is used.
Okay, and that's the completely separate question. The St. John's case from the 11th Circuit was vacated. Does that mean that the district court case is precedent?
Well, it was vacated, so it's not necessarily precedent because the 11th Circuit originally affirmed it, and then the 11th Circuit said, no, we are changing our mind and we're completely vacating it, and we're going to go ahead and re-rule on it through an en banc hearing with all the justices. So at this point, that is the case that's out there, so you could make an argument that is persuasive and precedent. I would be careful to do that because I know very well that the 11th Circuit is rehearing this. So that would be my position.
Okay, so I think you all know, based on the conversations we've had here at the table, that this issue specifically with regard to locker rooms makes me very, very, very uncomfortable as a parent. I want to start by saying that I completely accept transgender individuals for who they are. It is a real medical diagnosis, and our children are entitled to every accommodation, every reasonable and appropriate accommodation that we can provide to them. This is not, my comments are not a rejection of the diagnosis or our children's circumstances that are real. But I do believe that accommodations for adults and children are different. And I think that transgender bathroom and locker room use for adults is different for adults than it is for children. I think that we as board members have a unique responsibility, particularly when it comes to students, to preserve students' privacy. And to me, that means protecting a student from being in a position where they have to expose themselves to other students who don't match them biologically, or be exposed to students who don't match them biologically. I just, it's a feeling that I have deep in my core, and it's what I genuinely believe. I think as board members, we have to protect all students. That includes transgender students, and it includes students who want privacy from that exposure and from having to expose. I also think that a lot of the interpretation of the law that's going on is wrong. You guys talk about Title VII, it makes my head want to pop off. Title VII is not Title IX. Title VII was an employment context that contemplated how adults should behave. It had nothing to do with intimate facilities like bathrooms and locker rooms. Title IX specifically addresses children, and it specifically addresses intimate facilities. And at the time that law was passed, no one in the legislature was talking about transgender, gender identity, gender dysphoria being included in the definition of sex. I genuinely believe that this Supreme Court will not define sex to include gender identity. I believe this Supreme Court is a strict constructionist court that will send it back to the legislature for the legislature to make that decision. All of that being said, I think we as a board are powerless to do anything about it right now. I wanted to, coming into today, I wanted to suggest that we pass a policy regarding bathroom and locker room use, but I don't think we can do that under the law. I think that other districts are already in that case, and I think that it would be a waste of taxpayer resources for us to engage in a lawsuit that's already being decided by our courts. So what can we do while these cases are being decided to protect all students, not just transgender students, but all students? And I spoke briefly with Dr. Bernier about architectural changes in our buildings, and I'm not just talking about the new buildings we're building. I'm talking about dividers in our locker rooms. I've spoken with all of my kids who have been in various locker rooms throughout the district. They all change in open rooms. I'd like to see barriers placed in those rooms, if the board agrees, as a retrofitting measure, obviously based on cost. I mean, you know, I would ask you to come back with costs, see if there are piggybacks out there that we can utilize. And the other thing that could cut down on quite a bit of this is making sure that we're not penalizing kids who don't dress out for PE. Like, I know my son is in PE and he has to dress, and if he doesn't dress for PE, he gets knocked down in his grade. Well, there's no reason why he can't play basketball in his jeans if he's uncomfortable changing in the locker room. And the same is true for weightlifting or any of those activities that require dressing out. The other thing is I've spoken with colleagues across the state, and what I'm suggesting here is widely accepted as best practice. There is no appetite by other districts to engage in a lawsuit or policy making. All legal advice and all professional advice, all best practices are wait until this plays out in the courts. But in the meantime, what you can do is you can seek to retrofit your locker rooms. And I would suggest that that would be at the middle and high school level. Those are my comments for now.
Thank you. Ms. Giovanelli.
So that was kind of something I brought up a while back, you know, when we're building schools. Why aren't we looking into that? A little bit of a change, but have we engaged any of our students to see what they're comfortable with? And like, because I was thinking, do we need to retrofit a whole locker room, or do we just need to have a room designated area that, you know, separate bathroom and a changing area for just one person at a time, and they take turns? You know, what is the real need? Are we needing it for 10 students? Are we just needing it for 1 or 2? You know, because not necessarily transgender would decide to use that private bathroom or a locker, area to change in. It could be anyone. I remember I hated dressing out, so I understand, where privacy at a middle school age or in high school age could be is very important to some students. So I think it's something we need to engage our students and see exactly what the need is. If there's no law that makes us not do it or stops us from doing it, I think, and it's kind of like thinking out of the box and thinking ahead and planning, and we don't need a law to tell us to do that. I think we can do that on our own and accommodate students for whatever reason. It doesn't have to be, a gender issue, actually. Thank you.
Thank you.
Ms. Jordan? I just thank you for bringing that up, because I know firsthand from my kids and my grandkids now, they do not want to ever be dressed, because my middle schooler just came and said, do you know they wanted me to get dressed in front of all these other girls? And they're all girls, but to her, she was uncomfortable with doing that. So yes, she was given accommodations to go into a bathroom. So it is about accommodating all of our kids. And so I really appreciate you bringing that up. It is about the kids.
Ms. Gittens, the attorney.
Go ahead, Ms. Gittens, if you have a comment, then I have.
No, it's different, so go ahead.
So,
Attorney Bruno.
And I'm sure the superintendent also has a comment on this as well. There's nothing in the law that says we can't do that.
Right.
Right? There's nothing, absolutely nothing in the law that prevents us from having privacy barriers or having bathrooms that are anybody can use the bathroom. It doesn't matter what your gender is, et cetera. Absolutely nothing. What I do want to just make sure that it's clear. I just want to make sure that it's clear where we are with the law at this time with regards to transgender youth using the bathroom. The 11th, I can't predict what the United States Supreme Court's going to do or the Florida Supreme Court's going to do or what the 11th Circuit's going to do. I have a sense based on what the judges are in terms of the conservative or not conservative, but we cannot predict. So as you were saying, we do need to allow some of these cases to go through the process, and there are cases out there. But as it stands right now, where we are with the law, Florida is very difficult because the one case has been vacated, even though we have the one order, but it's been vacated. And the United States Supreme Court did not choose to assist us by accepting Grimm to give us some guidance, to give us a review. They did not choose to do that. So they actually allowed that case to be law in the Fourth Circuit, which is like, 4+ states. That is the law, and that is the federal law as it stands when you're trying to figure out where the court's going to go. So it is a little difficult. It's murky. I don't want to confuse anything with regards to the law. I just wanted to explain that, and I know the superintendent has additional comments. I'm assuming the superintendent has additional comments.
Passing the potato here.
I'm going to reserve my comments until the discussion is over.
Okay.
Can I jump in for just a minute? I just wanted to address Ms. Giovanelli and Ms. Patrica that our guidance does include, at the request of any student, a gender-neutral, single-stall, private restroom, locker room may be provided but cannot be required. Gender-neutral, single-stall, private restroom, locker room options do not require parent permission as they are available to all students.
Yes.
Thank you.
Okay. Ms. Gittens? Okay. My question is about the gender support plan. And I was looking at it, and it is from genderspectrum.org. So it was an already available form. What vetting did we do? Have we adopted it? Did we adapt it before we adopted it? Or, and does it suffice legally in our situation? Is that clear?
It's clear.
Before you answer, may I, Ms. Fisher?
I'm sorry.
May I add on to Ms. Gittens?
Yes.
Okay, so before you answer that, can you please, because I know it was revised in 2019, so this thing has been here for, and I think Ms. Fisher was aware of it, like for many, many years. So there you go. I just wanted to add that little.
And actually, if I may, that's one of the reasons, since the law is as of 22, does it reflect everything we need to reflect?
And once again, I'll respond to kind of several of those questions. First, there was never a formal adoption. It was recommended as a best practice document, and it was provided through several groups through the Florida Department of Education, that this was a tool that could be used in helping to support persons regarding their gender identity. As I mentioned previously to Ms. Patrica's question, we would be happy to go back through the document and make sure that it is aligned to the current state laws of Florida.
And with that, then, should it also be vetted, like, by the group that looked at everything else? I mean, I'm just wanting to make sure that it fits with the law and it fits with what the community saw already. Was it something that you did go over in the training? And what was the response?
So we did share the document. We didn't go over the document like line by line or do a deep dive into it. That's something we can do with future work. The things to point out with this document that are important, that it is individualized, it is confidential, it stays with the school counselor. A student is not required to have this. This is for a student who wants accommodations, and at that point we work with them and facilitate a conversation with the family and help them through that. And it highlights and makes a priority confidentiality, privacy, and safety. And everything in the plan looks at the student through that lens of confidentiality, privacy, and safety.
So a suggestion, at the top where it says confidential, an asterisk, and at the bottom of the page in reference to the portion of the law that says, you know, when parents have to be notified and all that, just having the FS, whatever it is, just so that we know what confidential means, because just sitting there by itself, it could have a lot of interpretation.
And Ms. Gittens, excuse me, Attorney Bruno has comment.
Yes, I do. So House Bill 1557 does talk about support plans. And what it specifically says is that we cannot adopt processes or support plans that prohibit the school district from discussing changes, services on the monitoring of students based on their health, their physical health, their mental health, their emotional health, and their well-being. So long as we are making sure that parents are involved and that they know when services, which the gender support plan would be, services are being rendered or being monitored, then the parents have to know, and that will be in compliance with House Bill 1557.
So one of the things that jumps out at me in the first block, the question, sex assigned at birth. And what would trigger asking a student that information or getting that information or whatever? If, you know, they come dressed differently than they did yesterday or last week, or what besides this form, what would trigger asking that question?
The sex assigned at birth?
Yeah.
Well, that would be part of their student record. We would have that information already. That's provided on enrollment.
Ms. Gittens, if I'm understanding the question correctly, you would like to know at what point does this form start to get filled out, beginning with that first question, sex assigned at birth?
And is it generated by the student?
So staff, the question really to you is, how does this form come out of a drawer or out of a computer?
And get filled
and
out.
for what purpose? So how does this become, you know, from a conceptual idea of filling out a gender equity plan to actually somebody sitting down? Can you give us the scenario in which this form would be put into use?
A student goes to their school counselor and says they want to talk about their gender identity, they have questions, they want to talk through some things. The school counselor talks to them, and at some point in that conversation, or maybe the next conversation, the student says, these are the pronouns that I go by, and I would like everybody to use these pronouns. At that point, the school counselor would share that they are welcome to use those in the schools with their friends, but if the adults and the personnel in the school are going to use those, then that has to be part of their plan. with this plan. Not every part is going to be applicable to every student, and it's not like you have to fill out each section to go to the next, but they would talk about this plan to the student, so that would be the process in every school. Now, what the plan looks like might be individualized, but at that point, when the student asks for accommodations, they would be.
It is also possible to have a scenario where a parent came in with their child.
Correct.
And engaged with an administrator or a school counselor or another member of the staff, asking for this plan to come as well. And let us be clear for the public, in the first scenario you just described, where a student is self-identifying, at what point is the parent involved before the form begins to be completed?
Right from that very first meeting, there would be, the student would be informed that to really complete this plan, it would require the involvement of the parent, and there would be encouragement on how would we make that happen. So if that is where the student wants to go, then it would be a conversation about how are we going to get your parent involved?
And if I may, a third possibility is a bullying situation in which the administrators and guidance counselors are involved, and it comes down to why was the bullying, and it had to do, with this topic. So therefore, that's another thing that could trigger it. But then in that case, would the student have to say, yes, I'm being bullied, and yes, I'd like to have a plan?
Yes. So at that point, because the bullying would be handled through bullying harassment, we have students that are bullied for their actual and perceived sexual or gender identity, sexual orientation, gender identity. So that's handled separately. But if out of that, a student then says, I do want accommodations on campus, then we would start to head into this process.
I think where it gets a little sticky for parents, and you know where I'm going with this, that if it's a bullying situation and the students are called in and it's unearthed that this is the reason for the bullying, parents will probably ask, were they encouraged in order to stop the bullying to have a gender support plan? I just kind of feel like that may be a question, and I don't know if we have an answer for it now, but I could see someone.
I have a basic answer, which is we as a school district, we're a public school district, we're neither here to prohibit nor promote. And so in that case, we're not going to encourage the student to have a gender support plan unless they feel the need to have one. We're going to, we would want the student to bring that forth and or the parent to bring that forth, and then work with both student and parent.
But in that conversation about the bullying, somewhere along the line there is, we can do this, we can do this, we can do this. You think?
You can.
Part of those could also be part of the bullying plan, so the bullying investigation also results in a plan if there's determined to be bullying.
Okay, thank you. Okay. Ms. Jordan.
Just real quick, thank you for saying that for the bullying plan, because also with harassment and every time there's any kind of issue, there is a plan put in place to protect the child.
Correct.
Thank you.
Thank you. Okay, Ms. Chivinelli.
Just real quick, one of the questions I actually had was regarding clubs and participation. I know in the past, we've been told that cheerleading is considered really a club, not a sport, except for Riverdale, I believe. They're the only ones that's a competitive sport and treated as such. But yet, I see some schools that have males on some cheerleaders, but I don't know that all schools are encouraging that, or and it's all schools do it differently. Even right now, still even to even tryouts, that's not the same. And even though we were supposed to have it the same, and we went through that whole process, and that never really came to real fruition. How are we handling that? Why isn't that consistent throughout the district? And I don't know if that might be a question.
I don't know that that's fair to the gender equity experts that we
Yeah.
have in the room, as well as the individuals that participated in the work that we've been reviewing today. It is an issue that I'm more than willing to take up with David LaRosa and have that conversation with an athletic director for our district. Talk a little about consistency among schools. With the reality of cheerleading, especially out on the track, it has been open to both young men and young ladies, no matter how they identify. And if you look at collegiate teams, there are some really amazing opportunities for young men for scholarships and other things. So young men, or I'm not even going to do it. So we'll look into that process for consistency.
I just know not all schools encourage the males to, and really good squads have men on them, actually, regardless. So, that's all. I just don't see it consistent.
Thank you.
Thank you.
So Madam Chair, in the sake of time, can I just make a couple of comments before you
Yes.
potentially close us
I'm just
out unless
worried-
there's another board member
I'm
that...
just worried about Ms. Patrica having to leave at 4, so when she leaves, just ignore her.
Well, I won't ignore her, but I can be done in 3 minutes for sure. What I've heard are several things that I think are of value for us to take away. First and foremost, I really do appreciate every board member being thankful to this team, to the individuals who lie beneath them in the organizational chart, who did a lot of the work to helping all the small groups and all the work be done. Again, also to the community that's present for their work in terms of being supportive. If we had drawn up a community engagement plan, we would have drawn it up to be longer and more in-depth. But we had a looming due date of the school starting to have something in place. But I appreciate Chuck and Jessica from their aspect of saying this is not the last time you're going to hear about these issues. This is a very fluid situation at the moment. There are cases, to Ms. Patrica's comment, that are further along than anything we could establish or start. So it would be wise for us to allow those cases that are further along in the appellate world to come to fruition. I know our legal team and my 2 other quasi-legal counsels seated over there, they have become great stewards of the law. I think also I took away both the focus on parental involvement, which is very different from where the state was just 4 years ago when I left. The state was in a very different place when a very different place regarding these issues. And I'm happy to see that parental involvement has been brought back into the process, because I think parents have a right to be duly informed about some of the decisions that their children are making. And if decisions is not the right word, I apologize. And then finally, we have already begun a conversation with Scott Rickenbacker and the construction group, not only for our new construction, but also looking at when we renovate. I will ask further for us to look at the schools that are not currently on a renovation list and follow through on that ask for what it might cost. And then finally, I will also spend some time with our curriculum services people who are in charge of physical education, and we look at the policy for dressing out.
Thank you.
Because there can be some issues, and we want to be respectful, again, of protecting all of our students. And that's why I love the title of this guide. It's a civil rights and equity guide. It's how we should take care of all children. And I appreciate people trying to find a middle ground, knowing that we'll move forward based upon case law and other changes to our own status and own curriculums and own expectations.
Thank you. And before you leave, I just wanted to make a couple of comments. I wanted to thank you for the presentation, which was concise yet comprehensive. I think that the community committee was diverse, and I heard amazing feedback from some of the members. I think the input was good, particularly from the students. And so your little triangle of student success, the student, teacher, and parent, that's always been, I think, our philosophy, that parents are our partners in education. And as a former school counselor who worked with these issues, even before I got on the board 12 years ago, when it wasn't a big thing publicly, we accommodate for kids, and we do take it on a case-by-case basis. And whether it's a gender identity issue or another issue that a student has, we do provide for kids to have privacy and to be safe and taken care of. So thank you for your work, and I think this was a great presentation, and we're right on time.
Great job.
Thank you so much.
Thank you.
Yes. Okay, so then next on the agenda
Public comment.
is, okay, public comment, I think.
It is.
Public comment.
I lost it, okay. Attorney Bruno, will you please address the issue of public comment?
Thank you, Madam Chair. School board policy provides the opportunity at this point in the meeting to address the board concerning any matter on this meeting's agenda. If you completed a public comment card, please make sure that it has been provided to staff. The public comment will be held at the podium in the center aisle in the front. Please be advised that the board will not respond during public comment to remarks made by speakers. Speakers who fail to follow proper decorum in the chambers will be ruled out of order. Any speaker continuing with such remarks will be required to relinquish the microphone per Board Policy 1.11 and may be removed from the chambers. There will be one warning. Per Board Policy 1.11, the time per speaker is 3 minutes. You will find a countdown on the big screen in the front of the room. Once your time has elapsed, the microphone will automatically shut off. Please state your name when you approach the microphone. Please follow the staff direction when lining up. Madam Chair, there are 3 speakers which wish to address the board during this briefing.
Thank you. Is there anyone else in the audience who did not fill out a card and would like to speak? Okay, seeing none, will you please call the first name?
Thank you. Will the following individuals please line up? Robert Roper, Sharon McGill, Jamie Merchant. Yes, and come down to the center aisle at the podium in the front. Thank you, Ms. Merchant. Stay right where you are. That's perfect. Thank you.
Okay, my name is Robert Roper. I do also want to commend Mr. Bradley and Ms. Duncan and the whole team. They were amazing to work with. In fact, I was the one that requested a class reunion sometime in the future. I thought it was a very good thing. Contrary to popular reporting in the media, there is no registry being assembled. It's not possible. Students have privacy rights. That's just not a thing. I'm seeing now, maybe for the first time, the enormity and the complexity of creating policy to comply with the law. Thank you, Board and Ms. Bruno, for being so diligent in that area concerning the Civil Rights and Equity Guide. This still needs to be in the Student Code of Conduct. I still beg you, a one-pager that was promised when we had 400 people in here. We said there would be a one-pager. There needs to be a one-pager that needs to be a policy, and then you can link to this 14 or 18 pages, whatever it comes out to be. It needs to be a policy because it needs to have come before the public to be revised. The guidance can be revised by staff at any point in time without public's knowledge of it. It has to be a policy. This guide, I believe, is too large for a parent to read. If you follow all the links in the Florida statutes and the titles, I just don't think it's reasonable to think that a parent is going to do all that. As far as a persistent, consistent transgender male identifying as a female in the females' restrooms, because that's what they want, and they get the equity plan, of the gender support plan, and they get what they've requested. That person has that right, and I support that person's right. However, all the other students have a right to have their parents notified that that's what's happening, because there is an expectation of privacy in the restroom, and just because you've granted a right to one person doesn't remove the rights of the others. I did provide a comprehensive report on June 30th to this entire guide, and to date I haven't really received any feedback. 20 seconds left, and with all these policies at one time, I'll just end it this way. It is impossible to get public comment when you have this many policies at one time. Just impossible. But there is a glaring problem, and I'll get with you, Ms. Bruno, because I think I'm done.
Thank you, Mr. Roper.
This is fun. I like this. I can see you all. Jamie Merchant. I was chosen to be part of the community feedback for the equity guide, and I greatly appreciate that opportunity. I learned a lot. I know that Chuck and Jessica worked very hard on this project, and still to this day, I'm still researching things that I've learned throughout those 3 days of meetings. The topic on abuse. You have 96,000 or more students enrolled in your schools, and to assume that any of them are abused without any sort of proof or documentation from the authorities is a stretch. And I think to take that to specific to those who are transitioning or want a gender support plan is not just, I always encourage parental involvement. There should be a guidance counselor on staff that should be trusted to encourage the child to have a conversation with their parent or be that third party with their parent instead of conversations happening behind closed doors because the child has not asked for an accommodation. So those are my comments. Thanks.
Thank you.
Good afternoon.
Good afternoon.
Sharon, let me try to take this out. Sharon McGill, and I was part of the Equity Guide Committee, and it was a wonderful group. I mean, it really was. When we broke off into our small groups, we would sometimes get off target and start talking about all these different things, and either Jessica or whoever happened to be at the table with us would always try to circle us back to where we were actually supposed to be. But it was all good conversation that we were having, which was great. The only things that I'm concerned about is, and this came up in our group with several people, is the implementation of all of these policies, and that they're consistent across the district, by schools, by ages, because a parent could have a child in one school and they end up having it reinforced a different way than if they're in another school, the way it's interpreted by that school's administration, which can then be confusing for the parents. And not knowing, okay, what do I do here? What do I do there? So that was just something that came up, was how is it going to be implemented, and will it be implemented consistently? The other thing that came up all the time was website, website, website. You keep telling us it's on the website, but we can't find it. I mean, it's like going through pages and pages and pages. It really has to be a simpler process for people to find that information. And then last, I think that a lot of these policies protect the students, but I think the teachers in some of the cases are left out. And how some of these policies like harassment, how does the teacher get protected from that? Because a child is very, very capable of harassing an adult. And so what's the process, and how are the teachers protected from harassment and bullying, physically and verbally, by students? And what's the process with that? And then one last thing, the teachers are given a personal space in their room, which I guess is their desk. So on their desk, they can have personal items. Nowhere else in the room, but on their desk, they can have personal items. But how are they protected if they have a picture of the two moms or the two dads together on a mug sitting on their desk, and a child goes home and says, oh, did you know what I saw on my teacher's desk today? And the teacher can't discuss it with them because that's against the law now. So how is the teacher then going to be protected if the parent comes back and complains, well, my child saw that you had this mug with 2 moms or 2 dads on your desk? So it's about the teachers and some of these incidents. Thank you.
Thank you. Thank you. Thank you all for participating in the committee and for sharing your comments with us, and staff will be working on all of that. Dr. Bernier, do you have any further comments in response?
Just as a quick point related to that, our teachers have many of the same protections. Our Human Resources Department works very closely with our teachers. They are well protected as an employment class, as well as our classified staff and other employees. And additionally, I'll defer to Kathy Dupuy-Bruno if she wants to weigh in, but we have tackled that item of pictures and mugs on an individual's desk. Those are permissible. They have the right to have those things on their desk. And believe it or not, the law would protect them, provided that it engage in a proactive or protracted conversation regarding their relationship. It would be inappropriate for me to share my relationship with the students I'm responsible for. It's just not a topic of conversation. It goes back to our idea of teaching to standards. We have a lot of room within teaching of standards. We don't have a lot of room for deep personal expression regarding that type of issue.
If I may, Ms. Fisher?
Yes, please.
Just a couple of things. The anti-discrimination policy, the anti-bullying harassment policy applies to staff as well. So it's not just for students. All of the civil rights law apply to staff as well. And finally, with regards to the picture on the desk, the personal item, we know that this is allowed because in the response, the governor filed a motion to dismiss a case that is pending currently on House Bill 1557. And in that motion to dismiss, made it very clear that having a picture of your spouse on your desk and those types of things are not applicable by the law because they are not a form of instruction. So long as there is not instruction, that's where the violation of 1557 will take place.
Thank you. Okay. Next on the agenda is board comments. Ms. Morgan, do you have anything right now?
No, I'll share mine this evening. Thank you.
Thank you. Ms. Vaughn?
Nothing to share right now.
Ms. Gittens?
I have a couple of things I'll share this evening, but this one is kind of a funny for Ms. Giovanelli.
Okay.
On Saturday, I participated in a book bag giveaway in Lehigh, and there were costumes, and there were different people, and someone said, oh, we don't have anyone to wear the taco hat. So you will see pictures of me, and I had titled myself Taco Tuesday.
But it wasn't Tuesday.
It wasn't, it was Taco Tuesday on Saturday was my complete name. So I just wanted you to know that we are following through with Taco Tuesday, and also there's a lot of the backpack giveaways happening in the community, and I just want to say thank you to all the organizations and companies and all of that saw fit to do that for our students and to help them. It takes a village, and that was a great part of the village help. Thank you.
Thank you. Ms. Jordan?
I am good for now, thank you.
Okay, Ms. Giovanelli?
I don't have much either, other than there's an event this weekend at Fort Myers Middle Academy with Pick Up the Ball, and it's a community involvement event. I think it's the first one, so I look forward to hearing how well and successful that is. I do want to bring up something that came up yesterday at Good of the Order, and I left concerned, and we didn't talk about it, and I don't want to talk about it in depth too much, but it was regarding Ms. Morgan's email. I actually personally called Mr. Quick, and he advised that we wouldn't have any kind of conversation regarding, because of the present investigation, ongoing investigation with the whistleblower complaint. And feel free to contact contact him yourself and maybe get more information from him, but it's not recommended that we even have a conversation at this time regarding that. So I would recommend, for me, at this point, I would leave it as status quo until the investigation's resolved.
And I'm sorry,
Anybody
that
else?
was regarding what?
The email that Ms. Morgan sent yesterday
Oh, okay.
regarding our board attorney, so.
Okay, thank you.
Thank you.
Ms. Jordan?
And I'm sorry, I am remiss that I was going to bring that up, and I totally blitzed that, listened to everything else today. And I had the same conversation with Mr. Quick as well.
Thank you. Okay.
And I apologize, I totally forgot it.
And I'll save my comments for later this evening. And so Attorney Bruno?
I don't have any comments.
Okay, and
Nothing
Dr.
else.
Bernier? Okay. Seeing no further business, I'll remind you that at 5:05, we will reconvene for the tentative budget. And at 6 o'clock, we'll have our action meeting. And seeing no further business come before this board, this meeting is adjourned. Thank you all for being here.